May I please you?
Yes.
I am mentioning for listing for a bail application, my lord, filed on 22, my lord. Today 61 days already mandatory period is offer, my lord. Can it be listed on today, my lord? My lord, for listing, my lord. I have filed on 22.
When to be listed? Today?
Today, my lord. For motion, mandatory period is offer, my lord.
Okay. Okay.
Oblige, my lord.
May it please?
Yes.
I pay for listing of a bail application. Matter was directed to be listed today. And the petitioner is an advocate behind the bar for 22 days. If possible to move today, Lordship.
Today may not be possible because of mandatory period. We have allowed him.
Yes.
Tomorrow?
Tomorrow.
Okay.
May I please, Lordship? Lordship, in item 43 and 44, we have just filed two additional affidavits in the IS. Lordship, may allow to bring it on record
When?
today, Lordship.
Today.
Lordship, items affidavits filed today.
Acha, okay.
Complete.
Okay. Volume.
May I please, Your Lordship?
Yes.
One criminal revision petition which was supposed to be listed in the month of September, but matter has not been taken up till today. So matter may kindly be taken up on next Friday.
Friday? Yes.
Like to mention item number 27, Lordship.
Of today's list?
Yes, Lordship. 27.
27.
27, Lordship, we have not received the case diary.
So after the Lordship next week.
Next week. Okay, on the pair being made by Mr. PZ Dotto, learned counsel for the applicant, list the matter on
He did next week, Lordship.
next week. Okay.
On 9.
Interim order is there, Lordship.
Till then, interim order shall continue.
Oblige.
Maybe.
Yes.
I wish to mention item number 11, madam.
11.
I am the respondent, petitioner is Seth, madam. He is the petitioner, madam. Only the password for the game. And my senior, madam.
You inform the other side? Yes.
Yes.
Any objection? No. With consent from the other side, Mr. A.K. Azhar, learned counsel for the respondent number 2. Price for listing the matter. When?
After a week, Lordship.
Pardon?
Next week.
After a week.
My
Okay. After a week.
all right.
Is there any interim order?
There is that may kindly-
Okay. Interim. Till then, interim order shall continue.
All right.
Highly object. May I please, Lordship?
Yes.
Item 36, madam.
Item
36.
36.
Yes, there is not been listed, madam.
Well, the case diary not received, Lordship. 36.
Maybe date, madam, next week.
On the pair being made by Mr. D. Bora, learned counsel for the applicant, list the matter on
10th.
10. Okay. On that day, learned additional PP shall produce the case diary before this court.
No interim order, madam. Okay.
May I please, Your Lordship? Lordship, I beg for listing of a 439, Lordship. We have already filed it. Can it be day after tomorrow on Friday, Lordship?
Okay.
Highly obliged. May it please, Your Lordship.
Yes.
I will be allowed to move an urgent AB tomorrow.
Highly obliged. May it please, Your Lordship. Lordship,
Yeah.
I beg to mention for listing a bail application for motion for tomorrow, Lordship. Oblige, Your Lordship.
May I please, Lordship? Lordship, I beg to mention for listing of a criminal appeal, Lordship.
When?
12th of this month.
Okay. Okay.
On
If
11. Lordship, Thursday, 11.
Lordship, 12.
Last day.
Okay. Okay.
12. Evening.
May I please, Lordship? I beg to mention item number 33, Lordship.
Yes.
Case diary not received, Lordship.
Okay. On the pair being made by Miss Yogune, learned counsel for the applicant, list the matter after a week.
Lordship.
That is my lord. 18, Lordship.
18.
18.
Okay.
Lordship.
Is there any interim?
No.
No. Okay.
May I please?
Yes.
I beg to mention item number 25, Lordship. Better maybe password for the day, Lordship.
25.
Your good name?
I am in.
On the pair being made by Mr. Ayale, learned counsel for the learned counsel appearing on behalf of
The petitioner.
your name is not there.
On behalf of Mr. M.H. Ahmed.
M.
H. Ahmed.
Item number?
25.
His name is also not there.
Let me see, Lordship.
18 lords.
18.
Lordship,
Are you sure about the number?
Lordship,
Not sure.
What number? Case number. Year number you want.
Lordship, when matter reach, I will appear, Lordship.
Okay.
Wait, please, Lordship.
Yes.
Lordship, I beg to pray for listing of a criminal revision petition.
When?
Lordship, actually, Lordship, we had already filed it, but it has not been listed yet.
So when to be listed?
On last occasion, it was listed in Manish.
That's all right. When to be listed?
Lordship, it could not reach. So the matter is
When you want to be listed?
when? Apologies, Lordship. Day after tomorrow.
Day after tomorrow. Okay.
Much obliged.
Sorry, Lordship. Lordship, item number 24, okay.
24.
24
Yes.
weeks may be granted.
On the pair being made by Mr. So-and-so, learned counsel appearing on behalf of Mr. M.A. Ahmed, learned counsel for the accused, list the matter on
After 2 weeks, Lordship.
after a week,
After 2 weeks.
2 weeks.
Yes, Lordship. In the
Okay.
meantime, we will file additional affidavit, Lordship, as regards the new development of the case.
Okay, okay.
On 22.
Case there is not available.
Case there is
there?
not available.
Okay, on that day, the learned additional PP shall produce the case diary before this court.
Obliged.
Items from daily list. Item number 1, motion bail application.
May I please, Your Lordship? 439 application. Lordship.
Yes.
FIR is at page 9, Your Lordship.
So the allegations are serious in nature. We will peruse the case diary, no?
Already-
Case diary and injury report of the victim. Case diary and injury report of the victim on Borua when?
My lord, this summary PSK, Lordship, we'll fix it on next week, Lordship. 9, Lordship.
9.
9. Obliged.
Item 2,
May I please, Lordship?
Yes.
413 application. And the petitioner was arrested on 18 of December, my lord. After 15 days, my lord, they are behind the bar. The FIR, my lord, at page 7. And the FIR was lost by one police constable, Rintu Das, my lord, of Jurabad police station, alleging that one vehicle was coming from Meghalaya side and suddenly attacked him. It is very unbelievable, my lord.
Why?
One vehicle coming from the Meghalaya side and one police constable standing on the road. How this person will attack the police? My lord, factual situation, my lord, what happened, I have narrated under paragraph 5. This petitioner was standing on the road and one vehicle coming from the Meghalaya side, so far offending vehicle AS01 LC 7244 with full speed from Meghalaya side. And for this reason, the vehicle was stopped by the police, which resulted a friction happened in between the police on duty along with the person boarded on the vehicle. In between this person and this petitioner was standing on the road, and the boarded person already fled away from the spot, and vehicle was also kept by the police. Now the innocent person was standing, he has been arrested. This is the case. And nothing is there.
Borua, you call for the case diary?
My lord,
When?
15 days behind the bar.
Lord, this from Bokista, Lordship.
Bokista PS.
Fix it on next week, Lordship.
Next week.
Short date may be given.
Borua, can it be on Friday?
My lord, we'll try, Lordship.
Friday, this injury report along with
My
the
lord.
case diary.
My lord.
And vehicles document also, my lord, because it is not belongs to the petitioner. So far, this offending vehicle is concerned.
Okay, will case diary will reveal everything.
High level.
item 3,
Please, Lordship.
Yes.
Lordship, the petitioner was arrested on 16/12, Lordship.
Mm.
The allegation, the informant alleged that his sister has committed suicide out of certain, due to certain torture meted out to his sister by the accused number 1 and accused number 2, Lordship. Accused number 2, I am before your Lordship for accused number 2, Lordship. Sumesh Sharma. So he was arrested on 16/12, Lordship. There might be some relation, but as regards the allegation, the petitioner is not involved, Lordship. So his board university exam started on 15/12. He appeared on the first paper of the university exam of fifth semester. On 16/12, he has been arrested. But by this time he has missed his university exam also.
When?
It ended on 30/12. He missed it. 15/12 the examination started. On 15/12 he appeared for the first paper. On 16/12 he was arrested. So on 16 from 16/12 he is behind the bar.
Okay, Borua case diary. When?
Day after tomorrow, the accused number 1 in the FIR, he has already moved an anticipated bail application. It is fixed on day after tomorrow for case diary loss.
Day after.
The other cases fixed day after tomorrow, Lord. So case diary might come, Lord.
Okay, day after Friday.
Lots. The AB number 429.
Case diary on Friday.
AB number 4292 of 23 lots.
4292.
You take down in this way. Heard Mr. D. Das, learned counsel for the accused, and also heard Mr. R.J. Borua, learned additional PP. This application under section 439 services prepared by accused Someshwar Kauranya. Alias Somesh Sharma, who has been languishing in Jail Hazard in connection with Satya PS case number 136 of 2023 under section 306-34 IPC. The learned counsel for the accused submits that in connection with the same PS case number, the case diary has already been called for fixing the matter on
Day after tomorrow.
day after tomorrow in connection with AB number
4292 of 23 lots.
okay. And submits that case diary may be perused on that day to dispose of the present application also. Accordingly, it is provided that Registry shall take this bail application along with AB number so and so, and on that day, CD will be perused to dispose of the present application also.
And if your case.
Item 4.
May I please, Your Lordship?
Yes,
439 application, Lordship.
yes.
As of today, the present petitioner is behind the bar for 17 days. He is arrested on 16/12. Allegations are under section 120B, 467, 468, 386, 427, and 447 of IPC. Lordship, FIR is on page 12, Lordship.
Yes.
Present petitioner is not named in the FIR. Lordship. Present petitioner is a bona fide purchaser of the disputed land, which has been mentioned in the FIR. Purchased from co-accused Purveshwar Boro, who is named in the FIR.
Let the city come.
We'll examine the case diary.
Pardon?
We'll examine the case diary.
Yes, yes. When?
On 11 or so.
11. Okay.
Item number 5.
May I please, Lordship?
Yes.
Which was a revision petition, Lordship, against keeping order that Lordship kindly come to page number 23, Lordship. Next, sir, 2, Lordship. Against who have appeared before, Lordship.
Against the interim
Yes, Lord.
maintenance
Yes,
order,
Lord.
but the question is whether this petition is maintainable.
Yes,
Because it is against interim order.
yes, Lord.
Yes, Mr. Borua?
The item number 5, Lordship, we have not been made party, Lordship.
Acha, that is not a party.
Yes, Lordship.
Okay, let notice go.
Lordship, I have for prayer for interim, Lordship.
Interim.
Yes, Lordship.
No,
What the-
interim will be considered only when we will satisfy that the
Yes,
petition
Lordship,
is
I'm
maintainable.
Kindly, yes, Lordship, because the my wife, she has a job, Lordship, and then she has salary of 28,500. There is one thing. One more additional is that, Lordship, I have a property in the North Wadi, Lordship. She has taken the possession,
and whatever the rent she has been from there, she has collected all right from the very beginning, Lordship. At present, Lordship, I don't have the job. So, Lordship, it's not possible for me to give a single penny in the next day, Lordship. We speak for this month, Lordship, 11. For that, Lordship, kindly come to page number, Lordship. What I'm said, Lordship. Page number 48, Lordship. There is a relieving letter from my job, Lordship. And because I have to appear in every day in the
No,
court.
that aspect was taken care of by the learned court below.
Yes, Lordship. That was placed before the court below, Lordship. Despite that, Lordship, there's a huge amount, Lordship. At present, I cannot. That's why I appraised before, Lordship. Myself,
That's all right. But the question is whether the petition is maintainable. It is against interim order.
Yes, Lordship.
Whether
But,
revision is maintainable
Lordship,
against interim order.
At least some observation may be given, Lordship, because all of the details have been placed before the court, clear, Lordship.
No, what
Despite that,
observation?
all this, Lordship, Lordship. Because whatever I.
No, we will do that. But prior to that, you have to satisfy the court that the petition is maintainable.
Yes.
Okay, we will issue notice at this stage.
Yes.
We will hear it on the point of
Lordship,
maintainability.
kindly till 11th
No,
of this
no.
month, kindly, Lordship.
No. Heard, Mister, your good name, please.
Peace, Lordship.
B. Sinha, learned counsel for the petitioner. Legality, propriety, and correctness of the order dated 11/12/2023 passed by the learned principal Judge Family Court. Number 2, Kamrup M, Guwahati, in FC within bracket criminal number 487 of 2022 is put to challenge in this petition under section 397/401 read with section 482 of the Code of Criminal Procedure. It is to be noted here that by the impugned order dated 11/12/2023, the learned principal Judge Family Court number 2, Kamrup M, Guwahati, has directed the petitioner to pay interim maintenance to the respondent at the rate of rupees 20,000 per month. Where is the petition and the documents flash on record? Let notice be issued to the respondent, returnable in 4 weeks. Step be taken by registered post and also by usual process within a from today. Registrar shall call for the scan copy of the record from the learned court below. Interim period of the petitioner will be considered after receiving the record from the learned court below. The question of maintainability of the petition is also kept open. Place the matter after 4 weeks.
Item number 6.
My lord, in this case, my lord, the petitioner is died on 2/12/2020.
Now you want to withdraw the petition?
The proceeding may be dropped, my lord.
Proceeding may be dropped. Heard, Mister, your good name, please.
Lordship, who has died?
The petitioner, Abdul Shukur.
Lord, proceeding may not be dropped. He may approach the court of law, the law court below. He may withdraw the criminal petition. It may be closed.
And that's why he has submitted. It may
This
be closed.
proceeding, which proceeding he is talking about?
So, my lord, I may be allowed to submit before the learned trial court, my lord, to drop the proceeding.
Here he,
The whole
yes.
proceeding.
No, we can drop this proceeding here.
Instant proceeding, criminal
Yes.
petition. Yes,
Yes.
it may be closed.
Yes. Heard Mr. S.R. Sodori, learned counsel for the petitioner, and also heard Ms. B. Sharma. No, B. Chaudhary.
B. Bhuyamai,
Sorry. B. Boya. Learned additional PP
Lordship.
for the state respondent. The learned counsel for the petitioner submits that the petitioner suffered demise and as such, this criminal petition may be closed. in view of the submission of learned counsel for the petitioner, and also in view of the submission of learned additional PP, this criminal petition stands closed.
Interim order, if any, would be vacated.
No interim order.
Is there any interim
No
order?
It may be observed, my lord.
Interim order, if any, passed earlier, stands vacated.
My lord, one observation, my lord, I may be allowed to submit before the learned trial court. To
But he
drop
has
the
not
proceeding.
submitted anything as a death certificate and all, my lord. It's up to
Everything
him.
is I have, my lord. If any death certificate subject to the confirmation of death certificate, my lord, before the learned trial.
Is it necessary?
No,
Because
may not be necessary.
not necessary. You can approve.
Apply.
Item 7.
May it please your lordship.
Yes.
My lord, second 430 application, my lord. The earlier order, my lord, is at page number 18.
So that was disposed of after perusing the case there.
Yes, my lord.
Yes,
Madam, you call for the case there?
yes, my lord.
When?
Up to date case diary to come with me.
Yeah, come up, yeah.
BIO?
BIO, your lordship, after a week,
After a week?
lordship.
No,
There
next
be after
Monday,
Bihu
next
holidays,
Monday.
Bihu holidays, after Bihu holidays,
It will be too long.
Too long,
too long.
On 11.
11, 12 months.
Yes,
11.
On
Yeah,
11,
sure.
12.
Highly obliged.
Item 8.
May I please your lordship?
Yes.
Lordship, I am trying to pass over timing, lordship.
Okay.
Item 9.
May I please your lordship?
Yes.
Whether the petitioner and the informant both are one of the singer,
Voter?
by profession singer, and they always participate in the different program, cultural program. And she stated in the FIR, page 10, that 3/4 months ago, that means she did not confirm in which date, 3-4 months ago, the accused person called me to his rented house at village so and so, and there is a culture program. When I came to the accused person's rented house, taking the advantage of nobody presence, forcefully established physical relation with me. And again, another allegation also mentioned here that another day also make the physical relation. And this time the FIR she filed saying that so many occasions, and she's 26 years old, my lord. And he present petitioner is a married person. And his present petitioner submission is that, my lord, they have just friendship, my lord. And now she's forced to marry her. And she could not marry because he's my lord, married person having children. Now she lost the affair. In fact, my lord, no such allegation is my lord, against him, my lord. And my lord, it is not a case.
Okay, let the
CDP
city
call
come
for,
along with 164 statement.
yes,
My lord, FIR
no
said-
interim, my
No,
lord.
so many occasions, my lord, Nazar girl, my lord. While a girl cannot say in which particular day offence was committed, very unfortunate, my lord. If anybody filed the affair saying that 3-4 months ago, 3-4 months back, one day,
CD will
committed,
reveal,
my
your
lord, it is a
lordship.
case of 376, my lord.
No, that's
No,
all it, but FIR is not the encyclopedia.
Yes, my lord.
Even then, my lord, case of 376, my lord, her case, as per her case, I am submitting, my lord. She cannot say in which the offence was committed.
Let the
Very
164
unfortunate,
statement.
Yes, my lord.
Very
Case diary
unfortunate, my
along
lord.
with 164 statement on, madam,
Lordship, after Bihu,
after Bihu. Let us try prior to
Bihu.
vacation.
11th, Thursday,
11.
11.
Okay.
Item 10.
My lord,
Ma'am, please your lordship. The 438 application lordship. Also will find the FIR on page 9 lordship.
Yes,
This is the FIR. May I read it, lordship?
not necessary.
Lordship will kindly turn to page 4, paragraph 7, lordship. This is the background of the case, lordship. There a marriage party was going on, lordship. At midnight, lordship, the vehicle was not parked properly, lordship. That person, lordship, the informant came out of his vehicle as the road was blocked with the vehicle,
and he was in a drunken condition, Lordship. He misbehaved some of the people of the marriage hall, Lordship. And thereafter, Lordship, he started assaulted an aged person, Lordship. They all came out, Lordship. He is also one of the member of the marriage Lordship house. He came out, Lordship. At that point of time, Lordship, somehow they have managed to send him in a car, and they have side the vehicle which were parked in the roadside, Lordship. And thereafter, Lordship, regarding the injury but 326, Lordship, may I point out one thing, Lordship? That Lordship will turn to page 14, Lordship, is the order of this honorable court, Lordship. One person was arrested after lodging of this FIR, Lordship. And page 15 is the operative portion, Lordship. Page 15 is the operative portion. Third paragraph, Lordship, will kindly see. Third paragraph, Mr. Borua submits that the injury sustained by the informant are simple in nature, Lordship. So 326 will not come, Lordship. After reading the case diary and medical report, the order was passed, Lordship. Kindly, I pray for the interim, Lordship. I like the Lordship. That snatching of money, everything absolutely, because the person 3 were named, Lordship. The informant knows those person, Lordship. It's not a plain docaity, Lordship, or something else.
Lordship, but one of the factor, your Lordship, in the night hours, hooligans attack the Lordship. Incidents take place in Guwahati city also.
No, that I know, because all are named in the FIR,
You see in
Lordship.
the
How
TV,
a
my
person
lord?
will know, Lordship? They are known, Lordship. They are neighbor. Lordship, we kindly see the FIR. They all persons are named, Lordship. 3%.
Let the CD come, your Lordship, because the
Only we
other
are stuck because of the injury part, Lordship. That has been already cleared by this honorable court, Lordship, while passing the
that
order.
order referred by my learned friend after perusal of CD, it was passed. I leave it to your Lordship, but your Lordship takes place in various areas in the Guwahati city. We see in the TV.
Yeah,
No, this order was passed on 1812.
1812.
The case diary may be available in your office.
Hangagar. Let a short date be given then. He'll
Kindly,
get.
because, Lordship, I am not play like this, Lordship. If it is said
Lordship,
that unknown
tomorrow
person,
then my learned friend is saying, I know.
if it is-
Tomorrow.
We'll take it, Manoj, if the case is available.
Or day
Tomorrow.
after. Puro ki kaho?
It doesn't come, Lordship, then. Maybe send back, Lordship.
No, no,
He's
no, no.
attracted.
No, we will take it at 2 p.m. today. In the meantime, Borua, you inquire whether the case diary is available.
Yes.
If
Then
not
he'll get-
available,
He
then
might get his order absolute, my lord. Instead of paying for interim relief, Lordship, if
Okay.
nothing is there in the case.
Because
then-
of-
okay, 2 p.m.
Oh, Lordship.
Huh?
Much obliged, your Lordship. Much obliged. Much obliged.
Items for admission. At number 12.
Yeah, that's it.
Eight, please, your Lordship.
Okay.
Here the petitioner is arraigned as an accused person under 390, Lordship. Challenging the order dated 17/3/2021. Here the petitioner has been arrested as one of the accused. Lordship. Initially, the FIR was lodged in This is the new development. This is the new development. Okay. Already judgment has been passed in this case. Acquitting all the accused persons due to some new kinds of development.
No, the proceeding was earlier stayed.
Yes, okay. But here the judgment is reflected.
No, how can the court proceed with the case?
Okay, only against me the proceeding has been seen. Only against me, not against the other accused person.
Acha.
Yes, okay. So what has happened now? New development according to the judgment. I have produced the judgment. Okay. Some new development has changed that the informant and the accused person who were against whom the stay order was not passed. Okay.
Lordship, I am for the respondent number 2, Your Lordship. So, as per the latest development is concerned, Your Lordship, I need to take instruction from the informant, Your Lordship. Because I am not aware as to what the recent
No,
developments. are.
earlier, scan copy of the record and the CD was called for.
Yes.
Madam, have you gone through it?
No, I have not.
Informant of informant of. Yes, admin.
Okay, madam, can we do this? We'll fix it tomorrow.
Fine.
In the meantime, let him obtain instruction from the respondent number 2.
Lordship, I am for the informant, Your
Okay.
Lordship.
Okay, as agreed by learned advocates of both the parties, list the matter tomorrow. So as to enable Mr. Your good name,
A. Devan.
A. Devan, learned counsel for the respondent number 2 to obtain necessary instruction from the respondent number 2.
Obliged. Item 13.
Copy the deal.
May kindly produce order dated 22/9/2023. Okay, there is a scope for mediation between the parties.
Yes, Mr. Sinha?
Yes, ma'am. But if any date after 26 January, any date may be fixed for mediation, both the parties will come and they will sit here.
Good, sir. Heard Mr. B. Sinha, learned counsel for the, you are for the petitioner,
I'm for the petition.
and Mr.
A. Kakoti.
A. Kakote, learned counsel for the respondent. Referring to order dated 22/9/2023, the learned counsel for the respondent, Mr. E. Kakote, submits that there is chance for amicable settlement outside the court, and accordingly it is submitted that the matter may be referred to the mediation Guwahati High Court Mediation Center. Accordingly, it is provided that Registrar shall list the matter before the mediator, Guwahati High Court Mediation Center, on, you suggested it?
Any date, Lordship, after 26 January.
1st February. 1, 2,
Uh,
then 29th.
29. On that day, both the parties shall appear before the mediator, Guwahati High Court Mediation Center at 10 a.m.
Deeply obliged.
Item 14.
May please, Your Lordship.
Yes.
The petitioners have filed a petition under section 311 for recalling the witnesses for their further cross-examination, Your Lordship. Now, in the FIR, the complainant has alleged that the accused mercilessly beat them, and thereafter on the next day, the informant's father was killed by the petitioners. Thereafter, during the trial, the previous counsel, Your Lordship, he did not have proper communication with the clients, with the petitioners, and therefore he could not put some relevant questions which were necessary to be put. Thereafter, the petitioners, after they came out of jail, they engaged a new counsel. So that counsel has filed a petition for recalling the witnesses for their further cross-examination under section 311. That was rejected by this by a learned sessions judge down below. So therefore, we have filed this criminal revision petition challenging that order. If
Yes,
you not-
Mr. Bora?
Yes, my lord. We want to re-examine, my lord. Already all the witness has been over almost. That's why I'm saying, depend on lordship whether you consider lordship consider re-examination or not, my lord. Because already.
So what is the ground for re-examination?
Your Lordship, the earlier counsel.
Taken properly.
Yes, he did not coordinate with the petitioners here.
So some questions were there, necessary questions.
No, that is not the ground. That is not the ground.
And
That earlier council has not cooperated. That is not the ground.
yes,
For invoking the jurisdiction under section 311.
that communication could not be taken because the petitioners here, they were inside the jail. After they came out, they engaged a new counsel. So those questions, so he wants to put those questions, otherwise that petitioners will be prejudiced herein. So for proper
Where is the petition filed before the court below?
petition, your lordship will find at page 16.
Page
16, 1/6. Para 3, 4, and 6 will be relevant, your lordship.
Para 4.
Para 3, then 4 and 6.
Oh, what are the material question you have to show the court?
Your lordship, firstly,
And what are the new facts?
new facts that there was in the evidence, your lordship will find that this complainant has stated that she saw the petitioners shouting that line, your lordship will find was Neha. She stated that she saw Neha Begum was seated inside her own vehicle and was shouting "Ekebare Mari Pela." So on this point, the conducting lawyer of the accused person, without having proper instruction from the accused, failed to suggest that the aforesaid accused person were not present at the spot. So these things were not there in the statement, 161 statement, and thereafter in the 164 statement. These things subsequently came up in the evidence.
Mr. Bora, have you gone through the record?
No, my lord.
I have
LCR
checked
has
the
already
record.
come, my lord.
This particular
I have not
thing
gone through the LCR.
that this Neha Begum was inside the vehicle and shouting these words, these were not there in the initial statement, 161 and 164.
Madam, Estate is also a party here.
Yes, your lordship, may kindly have a look at the impugn order.
Yes.
At page 18. Learned trial court is elaborately dealt with the matter, my lord. Page 18, my lord.
Got it.
Yes,
Yes, that
last-
is clearly stated.
last three lines, last three paragraphs. Learned PP submission is that change of advocate cannot be the ground for allowing such prayer for cross-examination, recross examination, and that there is no such provision for recross examination. Learned advocate Shyam Doctor submitted that the court has its discretion under 11 to re-examine or call for any other witnesses' documents at any stage of inquiry or trial if it appears to be essential for just decisions of the case. Perusal of the 311 CRPC provides this power for the court, and the said power of the court are divided into two parts. One is may and other is shall. And this difference has been very clearly discussed by the Honorable Guwahati High Court in case of State of Assam as a Probin Paul reported in 2012 for GLT. This issue for recross examination without re-examination was referred to the High Court for decision, and accordingly in the said judgment, the High Court has replied in negative after carefully discussing the provision of Section 138 Evidence Act. Section 138 of the Evidence Act has not used the expression recross examination, which essentially is nothing but further cross-examination, which obviously follows re-examination. In other words, a witness can be re-examined in order to explain the matters referred to in the cross-examination, and if any new matter is, by permission of the court, introduced in a re-examination, the adverse party may further cross-examine upon that matter. The re-cross-examination therefore means further cross-examination of a witness who has been recalled and re-examined. Honorable Guwahati High Court held that expression re-cross-examination has not been provided in the Evidence Act, and hence re-cross-examination really means further cross-examination of witnesses who has been re-examined. In this instant case, there is no such re-examination of any witness, and as such, there can be no provision for the defense to cross-examine the PWs who were already cross-examined earlier. Simply on the change of advocate, and then certain questions were not put in the cross-examination cannot be the ground to re-cross-examination. Hence, petition so and so is devoid of merit.
So how the impugned order suffers from any illegality or
Your Lordship,
infirmity?
if these questions, they are relevant for proper adjudication, the court has the jurisdictionary power, the discretionary power to call for the witnesses examination.
Yeah, that's all right. That is well established.
Yes.
Hmm.
So otherwise, Your Lordship, if these questions cannot be put, I will be prejudiced in some way. So therefore, one chance may be granted. Your
Yes, sir.
At what stage the case is pending now?
I think the cross-examination, the evidence of PW is complete.
Completed.
Yes.
Doctor, may I pray the matter be fixed for admission hearing?
When?
Entire matter will be disposed of, or
When?
your lordship will, it's up to your lordship.
No, when? Tomorrow.
Yeah, BU is up to.
Tomorrow.
BU
If
is
Your
up to.
Lordship,
After the BU holidays.
or after.
BU holidays.
After no, madam, the evidence already completed there.
It
Yes.
will delay the trial process further.
Yes.
Otherwise. But we have to go. to
So
the-
then on Tuesday, next
On
Tuesday.
9 or 11, Tuesday or Thursday,
Oh,
9th or 11.
Oha Tuesday kuise kote?
Oh, 9th or 11.
9 will be.
9th.
Yes.
Okay, as agreed by learned advocates of both sides, rest is list the matter on 9th. And on that day, endeavor will be made to dispose of the matter.
Obliged.
Number 15.
May I place your Lordship? I'm praying for pass over the matter for time being.
Time being,
Yes, Lordship.
Lordship, in this case, LCRL has not received lordship.
LCR not received. When it was called for?
Lordship, last revision probably. They are seeking bail on the ground of that till more than 2 years has been happened, only 2 witnesses have been examined. We have filed affidavit, but Lordship, that is silent about how many witnesses. Like,
You have filed your affidavit.
we file our affidavit, but that is silent about how many witnesses have been examined. So LCR may be quite.
No, earlier LCR was not called for.
Status, it is status report.
Status report was called for.
It is also not come. That will do lots.
No, scan copy of the record has been received. It is stated in the office note.
I didn't find. Still in period.
Wait. So office note to misleading has been received by the registry. Call करा है Oh yes, Mr. Kyle, this status report has been received.
Yes, Lord.
2 PW has been examined.
I missed that part. Lord.
Pardon?
I missed that part also. I could not.
So what to do?
Maybe taken up day after tomorrow.
Day after tomorrow. Yes,
Lordship, at 2 PM, Lordship, today.
today. Are you ready, Mr. Kyle? Not ready. Tomorrow then?
Tomorrow.
Yes?
Today, Lordship, today 2 PM.
No, he is not prepared to argue the matter.
Lordship, we have to say.
Pardon?
Lordship, petitioner is behind the bar, Lordship, he has.
That's all right.
Lordship.
Kindly lordship at 2 p.m. lordship today.
No, if he is not able to argue the matter, how can we dispose of the matter? On the prayer being made by Mr. S.C. Kyle, learned standing counsel for the NCB, list the matter tomorrow,
Day after tomorrow, lordship. Day after tomorrow.
day after tomorrow. Okay.
My turn.
Item 16. 16.
None appears for the accused on call. The order dated 31/10/2023 indicates that on that day also the accused, the counsel for the accused remain absent. List the matter on Monday in the event of absence of counsel for the accused. Appropriate order shall follow.
Item number 17.
Yes,
Lordship 439 bill application, the substitute case, my lord.
Charge-cited.
Yes. Last occasion, LCR was called for. Scan could be already reached. Offense under section 489.
Scan copy has been received.
Yes, my lord. My lord, as per the scan copy, lordship.
Acha. What is this? The case is pending now.
My lord, it is fixed for my evidence test, lordship. On 30/10/2023, charges has been framed, lordship.
On
30/10/2023.
Under section?
Under section, my lord, 489A, 489B, and 489C, lordship. Now, lordship, the next date was fixed on 23/11/2023. On that day, no witnesses turned up, lordship, because someone was not served. The next date was fixed on 20/12/2023, lordship. That status is not, my lord, that update is not in the status report, lordship.
What is your instruction? Whether any witnesses have been examined? No.
Not ideal. Already 179 days, lordship. Only 10,000 rupees was found.
My lord, that is recovered and is promised possession, lordship, from the possession of the accused person.
As far as lordship, only 10,000 rupees. 179 days, lordship.
Some white papers are seized from his position. You are good matter then. He's behind the bar for 170?
79 days.
179 days. So what is your case then?
My case is lordship, actually falsely implicated lordship.
Falsely implicated.
As we have the daily labor lordship. From 2% lordship, 10,000 rupees was required. The lordship, the white paper which was recovered lordship, that may be wastage paper lordship.
Pardon?
White paper, those which were recovered lordship, that's a wastage paper lordship. It was found from our rented room lordship.
Yes, Borwa?
But this is a search state case, Lordship. After investigation, Lordship, police has found sufficient materials against him. That is the search state has been submitted. And now, Lordship, charges has also been framed, Lordship. Now it is a matter the stage of evidence, Lordship. Now, if this person is released on bail, Lordship, hit member will hamper the matter of trial, Lordship. Because if there is no material against him, then that is a different aspect with the matter.
Lordship, I am ready to furnish any kind of security. Surety,
The
Lordship.
question is that when there is material
I am
against
the
him,
person
it is collected, charges have been framed, Lordship, before the trial court. At this stage, Lordship, I am opposing his bail prayer.
Then I have to take defense, Lordship.
Okay, we'll see. We'll pass the order.
Dispose of it.
Yes.
Item number 18.
May I please, your lordship. What is the second application? Earlier, Honorable Court was rejected. And my lord, today is 61 days, my lord. And punishment is, my lord, 7A of PCR, my lord. So, 60 days, my lord, state will be below.
Then it will be
61 days.
Today, 61 days.
61 days.
7 of the PCA.
Mandatory period is 60 days.
60 days, man. The punishment is maximum 5 years.
Whether success has been submitted here?
No, but the investigation is pending.
Pending. So then he will get default bail.
But he'll get the default bail.
Yeah. Heard Mr. N. Islam, Learned Counsel Product. Anuddin, Learned Counsel Product applicant. No, accused. And also heard Mr. R.J. Bora, Learned Additional PP for the state restaurant. This application under section 439 services prepared by accused Muzammil Hussain alias Muzamuddin, who has been languishing in Jailazut in connection with ACB PS case number 94 of 2023 under section 7A PC Act since 4/11/2023 for grant of bail. It is to be noted here that above noted case has been registered on the basis of one FIR lost by one Ripu Setia on 4/11/2023. Mr. Uddin, Learned Counsel for the accused, submits that the accused is behind the bar for last 61 days and till then no search sheet has been submitted by the IO, and as such the accused is entitled to default bail as the mandatory period of detention for the offences committed by the allegedly committed by the accused is 60 days. And therefore it is contended to allow the petition. On the other hand, Mr. R.J. Barua, Learned Additional PP, submits that investigation has not yet been completed and no search sheet has been submitted till date. Para, having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record. And it appears that the accused was arrested on 4/11/2023 and he is languishing in jail as of for last 61 days. The mandatory period of detention has already been completed and no search sheet has been submitted till date. And therefore, this court is of the view that the accused is entitled to default bail. Accordingly, it is provided that on furnishing a bond of rupees 50,000 with one surety of like amount to the satisfaction of the learned chief judicial magistrate Northwood.
I think special judgment. Special judge
Acha.
Kamrup Metro.
Acha. A learned special judge
Kamrup Metro.
Kamrup, special judge Assam,
Assam, yes, Assam.
special judge Assam, the accused be enlarged on bail. In terms of above, this BA is disposal.
I'm obliged.
19.
No, 1930 submitted. May I please the lordship? It may be called for my.
Search it under section.
My lord, under section not mentioned in the my lord. 326A and 302, my lord. Subsequently, a victim is died. As per my information.
You go and approach the trial court then. Or we'll call for the search it.
Search it may be called for my lord.
Very initial stage, lordship. It will be very initial stage of my lord, because
Search it is submitted already.
the search is submitted, lordship.
Okay, let us search it come. We will examine it.
Lordship.
Heard, Mr.
HM.
Learned counsel for the accused and also heard Mr. Arjay Gurwa, learned additional PP for the state respondent. The learned counsel for the accused submits that after completion of investigation, the IO has submitted search it against the accused under section
326A and my lord 341, 302.
3,
302.
302. 302. And accordingly, it is provided that registry shall call for the scanned copy of the record along with the case date, fixing the matter before BU.
Before we on 11,
11.
item 20, item number 20, those final report submitted. Lord.
Final report. When?
My lord, on 20/12/2023.
Whether the person is behind the bar.
Behind the bar, Lordship.
Still.
Yes, Lordship.
Any other case?
Lordship.
Any other case pending
No,
against him?
Lordship. This case, Lordship. 1/12/2030 he was arrested, Lordship.
Ujjwal Lekhan.
Ujjwal Lekhan.
459,290, 452. Official PS case number 745.
Yes.
Final report submitted.
Final report.
My lord.
So why the person is behind the bar then?
Maybe lordship, my lord, that it was not intimated, lordship, or by the.
Pardon?
Maybe my lord, advocate has not intimated that board before.
The case is pending here. So how I inform Lordship?
Yes. He was arrested before my lord submission of the final report.
Yes, yes.
That is why.
1/12 Lordship was arrested. Today is 33 days.
Because prior to this, his bail application was my lord, probably not moved before the trial court.
Yes, sir. Yes, it's pending here.
Borwa, can you produce the final report before this court?
This is my lord, what's the kind of it should be confusing. And it was mentioned, sir, those who are verified. Looks to be kindly peruse the report. FFO, this is a CSO. Whether it is CS or final report, or say FF is also mentioned. That is.
No, search it submitted.
But FF is also mentioned. Lordship.
Yes, final form.
My lord, then my lord, search it, Lordship.
Okay, heard Mr. Your good name? Learned counsel for the accused and also heard Mr. RJ Boru, learned additional PP for the state respondent. Mr. Boru, learned additional PP submits that as per instruction, written instruction received by him, the IO has already completed investigation and returned the case in and submitted charge sheet being charge sheet number 524 of 2023 on 20th/12/2023. Accordingly, it is provided that the registry shall call for the scanned copy of the record along with the along with the case diary, fixing the matter.
Before behold.
Before behold,
So now it is certain has been submitted. It has to be called from the court below. Lordship.
yes, registry will call for.
Yes.
Yes,
On 11.
11.
Item 21. In this matter, Lordship, I am pressing on the length of detention. Today is 38 days, Lordship is in custody. And Lordship will kindly see the FIR. SCD was called for, Lordship, FIR and Action 1.
We have received the case diary. Lordship.
Yes.
Although volumes has been written.
No, only my lord, the injury report is my lord not available along with the case diary. Lordship.
Pardon?
Injury report of the victim, Lordship.
Yes.
That is not available along with the case report.
My
Otherwise, Lordship, there are eyewitnesses, Lordship, they have implicated this person, Lordship.
my instructions, Lordship, that goes, Lordship, that in fact nothing happened on that day. And that is why there is no injury report. All that have triggered his arrest, Lordship, was the concocted media report for which he was arrested. And this informant.
Yes, 14 is a FIR.
Yes, Lordship.
Page number?
Yes. Page number 14, 1 12. Annexure 1. FIR has been written in volume, Lordship. A lot of things indicating, but the victim is known in that particular locality for all these activities done by her. All these activities is creating disturbance for all. And I don't know whether in the case it is there or not. The entire people of the locality has given complaint against her. She is committing some mischievous activities there. I am submitting for instruction, Lordship.
Pardon?
I am submitting for instructions, Lordship. For instructions, I am submitting.
Yes.
That she is creating some disturbance in the entire Lutuma locality. And he.
No, she is 65 years old.
Yes, they say so. But perhaps it is not so, Lordship. The case that he may speak the truth. I don't know. And the entire people of the locality, they have given a complaint before the IO concern, whether it is there or not, I don't know, Lordship. But it is the instruction. And Lordship, nothing, in fact, nothing happened on that day. There was only one videography made, a concocted videography made, which triggered the arrest. But I am today purely on the length of detention. 38 days he is behind the bar now. As on today, 38 days. And his health condition is also not good, Lordship. Considering the length of detention, Lordship may kindly. Because by now, I think his statement has already been recorded. His further custodial detention cannot be warranted, Lordship. My brother has said that already statement of many witnesses has been recorded. That may be considered. FIR speaks a lot. There is no doubt. A lot of allegation has been made in the FIR. But these are not the true fact. But again, then it is a matter of trial. I cannot assert it right now. If your Lordship. My only submission as on today, Lordship, is considering the length of detention.
Mr. Borwa, you?
Yes, money.
Because by now, if his statement is recorded already, Lordship, his keeping behind the bar will be a mere formality. And he is a permanent resident of the locality, Lordship. There's no chance of his fleeing away from anywhere. He's having his own residence.
This medical legal report is available here.
No, but that is not clear, Lordship. But only, my lord, this is the, my lord, report wherein, Lordship, she was first, my lord, given some treatment, Lordship.
Because
After that, there has to be some, my lord, detailed report, Lordship, whether it is previous injury or not, Lordship.
Because Lordship, my instruction goes, Lordship, then nothing happened. No injury is there. I don't know what is there in the case diary, but it is absolutely I'm submitting from the instructions which I received.
No, witnesses said, Lordship, she was assaulted, Lordship. Witnesses said.
Yeah, assaulted. Now the
I,
definition
and
of,
they are,
definition
Lordship,
of
all I.
assault is very strange in the IPC. Even picking a blow speaks of assault, may not be hurt. Throwing a thumb is also an assault. Assault does not mean that somebody has been hurt.
In their report, only, my lord, mention about some abrasion, Lordship. That is not clear.
The medical officer has written whatever they found. There is no injury, that is why they have written only abrasion. In fact, my submission before Lordship has on today, Lordship. If his statement is recorded already, then further keeping him into custody is a mere formality also. Because arrest cannot be used as a pre-tool detention. Trial used as a trial if the charge sheet is filed. He is a local person, permanent resident of Lutuma, Lordship. This is the trial. Behind the butt for 38 days also. Only sole earning member of the family.
Okay, all right, Mr. Bhattacharya.
Lordship.
Heard Mr. Ebert as a learned counsel for the accused, and also heard Mr. R. Severo, learned additional pleading for the esteemed respondent. This application under section 439 services prepared by accused Orup Sharma, who has been languishing in jail as in connection with dispute PS case number 2211 2023 under section 341, 354, 354B, 325, 307 IPC for grant of bail. It is to be noted here that above noted case has been registered on the basis of an FIR lodged by one Lolita Rabha, one Srimati Lolita Rabha on 25/11/2023. The essence of allegation made in the FIR dated so and so is that on 24/11/2023 at about 4 p.m. one Arup Sharma has assaulted the mother of the informant while she went to his shop. And attempted to commit murder. And also fasten the clothes. Sorry, unfasten her clothes. The learned counsel for the accused submits that the accused is behind the bar for 38 days and that nothing has happened as alleged in the FIR. And considering the period of detention, it is contended to allow the accused to go on bail. On the other hand, Mr. R.J. Barua, learned additional PP, has produced the case study before this court and submits that the injury report of the victim is not available, but there are sufficient incriminating materials against the accused. And therefore, Mr. Barua has opposed the petition. Whereas, having heard the submission of learned advocates of both sides, I have gone to the petition and the documents placed on the record. And also perused the case with the assistance of Mr. Barua, learned additional PP. It is not in dispute that the accused has been languishing in jail as of since 24/11/2023. No, since 26/11/2023. Case diary, perusal of the case diary indicates that the material part of investigation is almost over and custodial detention of the accused, in the interest of investigation seems to be not warranted here in this case. And accordingly, considering the period of detention and also considering the fact that investigation has already been completed, the material part of the investigation has already been completed. Further custodial detention seems to be not warranted, and therefore it is therefore this court is inclined to allow this petition. It is provided that on furnishing a bond of rupees 50,000 with one security of like amount to the satisfaction of the learned chief judicial magistrate Kamrup and the accused being learned. Case diary be returned.
22.
Lordship will find at the affair at page 10. Page 10 is the affair. And is in custody as on date 47 days.
Yes, Mr. Borwa, you received the case diary?
My lord, we have received the case diary, lordship, and my lord, the investigating officer has collected sufficient materials, lordship, against this accused person. My lord, and this he is a habitual offender, lordship. My lord, he has, my lord, cheated this, my lord, a poor woman, lordship, and thereby, my lordship, the money was withdrawn from different ATM, lordship. That has already been collected by the investigating officer, lordship. And the investigation is still yet to be completed, lordship, because, my lord, some part of the investigation is still remain. So at this stage, lordship, I am opposing.
No, that's all right. You have opposed. Is there any material against him?
Yes, there is material, lordship. Because he is the person, lordship, who has accessed the, my lord, ATM card in the.
No, whether the informant has identified him.
Yes, my CCTV footage is there, lordship. That has been collected, lordship. Initially, informant could not identify, lordship, because she is a, my lord, illiterate lady, lordship, because she went to, my lord, to withdraw amount, lordship. And after that, my lord, CCTV footage, lordship, my lord, that has been enclosed along with the case diary, lordship.
47 days, my lord, in custody, my lord.
So what is this 401 and 413?
413 is a, my lord, 90 days of 413. Habitually dealing in stolen property, lordship.
Whether that section is attracted here.
That is
Definitely,
investigation
my
is
lord, not. Because lordship kindly see the, my lord, frauding report, my lord. What says in the frauding report, page 12, my lord.
No, as per forwarding report, you have been found interacting with the victim
My lord, the CCTV
and
footage-
also
CCTV
sending the card.
my lord, CCTV footage, my lord.
Initially, lordship,
Yes.
initially she could not understand anything, lordship. My lord, ATM card was exchanged, lordship. Then when she went to, my lordship, that day she could not withdraw any amount, lordship. After a few days, lordship, when she went to withdraw money, lordship, from the ATM, then she could know that her ATM card has been changed, lordship.
But considering the, my lord, detention period, my lord, 47 days. If he's, my lord, identified by the, my lord, informant, that the matter may, my lord.
And lordship, from this position of this accused person, lordship, 35 numbers of ATM card has been recovered. 35 numbers.
Can I see the case diary?
My lord. Recovery of so many ATMs, it's so private shows Lordship is a habitual offender, Lordship.
Heard Mr. M.E. Mondal, learned counsel for the accused, and also heard Mr. R.J. Godwa, learned additional PP for the state response. This application under section 439 says referred by accused Akhtar Hussain, who has been languishing in jail as in connection with Mosulpur PS case number 91 of 2023 under section 379 IPC, read with section 120B, 401, 413, 420 IPC. It is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Meena Munda on 27/10/2023. The essence of allegation made in the FIR dated so and so is that on 21/10/2023 at about 12 noon, C went to withdraw a sum of rupees 1,000 from SBI ATM. Situated near SBI branch, Mosulpur SBI branch, but she could not withdraw the amount, and then she handed over the card to one person. No, one of the three persons who were standing there, but he also could not withdraw the amount and return the ATM card to her. Thereafter, on 23rd/10/2023, she went to the CSP situated at Domoni to withdraw a sum of rupees 1,000. And then the person present in the CPO stated that the said card the card she possesses is not belonging to her. Thereafter, she checked the balance and found that a sum of rupees 11,500 have been withdrawn by some unknown culprits. Mr. Mandal, learned counsel for the accused, submits that the accused was arrested on 17/11/2023, and since then he has been languishing in jail as of for last 47 days. And that his name is not there in the FIR, and he has been arrested purely on suspicion, and therefore it is contended to allow the petition. On the other hand, Mr. R.J. Borua, learned additional PP, has produced the case theory before this court and submits that the IO has collected sufficient incriminating materials, including the CCTV footage of the ATM, and that he is a habitual offender, and therefore Mr. Borua has opposed the petition. But having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on record, and also perused the case theory with the assistance of Mr. Borua, learned additional PP. It appears that the IO has collected sufficient incriminating materials against the accused. The investigation is still going on, and enlarging the accused on bail at this stage will hamper the investigation. Accordingly, this court is of the view that this is not a fit case where the privilege of bail can be granted to the accused, and accordingly the petition stands dismissed. Case will be returned.
23
At this stage, my lord.
At this stage.
Obliged. My lord, 23. Yes, my lord, here lordship will find only affair is at phase 10, my lord. Same, my lord, identical nature of case. And he is in custody, my lord, for 45 days. Next week. 23 years. Okay.
Gogo, you received the case diary?
Yes, case diary received, my.
Is there any material?
Material is there against me, madam. Yes. It. Is a provincial offender of this type. Last thing, police note, my lord, that your lordship may peruse, and his 161 statement also. Good. Twenty-two, I think. Alphonse,
Oh, how many days he is behind the bar?
45 days.
45 days. Heard Mr. M. A. Mondal, learned counsel for the accused, and also heard Mr. B.B. Gogoi, learned additional PP for the state response. This application under section 439 CPC is preferred by accused Samir Ali, who has been languishing in jail as in connection with Mosul for PS case number 95 of 2023. under section 379 IPC, read with section 120B, 401, 413, 420 IPC. Since when he was arrested?
1911.
Since 1911, 2023. It is to be noted here that above noted cases been registered on the basis of one FIR lodged by one Topon Law Court on 7/11/2023. The essence of allegation made in the FIR dated so and so is that on 23rd/10/2023 at about 12 noon, he went to the SBI ATM to from Mosolpur SBI branch. Now, from the ATM situated near SBI branch, Mosolpur, to withdraw a sum of rupees 1,000. No, 10,000. But he could not succeed to withdraw the amount. Then he had given the card to one of the two boys who were present in the ATM. But the boy also could not withdraw the amount and return the card to him. Thereafter, on 6/11/2023, he went to withdraw some amount from the ATM situated near SBI Mosolpur, and then he has been told that the ATM card is not belonging to him. Thereafter, seeking the balance, he found that a sum of rupees 49,000 has been withdrawn from his account. Mr. Mondal, learned counsel for the accused, submits that the accused was arrested on 19/11/2023, and since then he is languishing in jail for the last 45 days, and that his name has not been mentioned in the FIR, and he has been arrested on suspicion, and therefore it is contended to allow the petition. Whereas Mr. B.B. Gogoi, learned additional PP, has produced the case diary before this court and submits that the IO has collected sufficient incriminating materials against the accused, and that investigation is going on. And therefore, Mr. Gogoi opposed in releasing the accused on bail at this stage. Having heard the submission of learned advocates on both sides, I have carefully gone to the petition and the documents placed on record, and also perused the case diary with the assistance of Mr. Gogoi, learned additional PP. The case diary indicates that the IO has collected sufficient incriminating materials against the accused, including the CCTV footage of the Mosolpur SBI ATM. Further, it appears that the investigation is still going on, and enlarging the accused on bail at this stage will hamper the investigation. And accordingly, this court is of the view that this is not a fit case where the privilege of bail can be granted to the accused. And accordingly, the petition is dismissed at this stage, and the case is later developed.
25. April lawsuit. The accused is behind the bars for last 30 days.
30 days.
30 days lawsuit. Page 10 is the FIR lawsuit.
Did he not receive person?
Lawsuit may peruse the FIR for a minute. It is filed by the Inspector of Food and Civil Supply lawsuit. I have the honor to state that the government of Assam has started paddy procurement policy in the state of Assam to uplift the economic condition of the farmers who are paying them the minimum support price at rupees such and such per quintal for paddy. But Sri Kamal Kumar, such and such of Kunkuni rice mill, Morigaon, has engaged some illegal trader to purchase paddy much below the price of MSP fixed by the government, taking advantage of the poor economic condition of the farmer and thus hitting the farmers of their MSP and creating hindrance in the government policy of procurement by depriving the farmers of the due right to sell paddy. The allegation is that
I have purchased rice below the minimum support price. And his lordship behind the bar since last 30 days. And on instruction I'm submitting that nowadays no one sells the rice below MSP. And lordship assuming if the rice has been purchased below MSP also, then also it's not an offense, lordship, because minimum support price is guaranteed by the government. In case the farmer fails to find any person purchasing the rice, then government will purchase at that price. That is the lordship scheme of MSP. And during this time, lordship, the seized paddy has already been handed over to the owner of the mill, lordship. This is the order of the land region, lordship, already handing over the entire zimma of the entire rice and paddies. 30 days behind the bar, lordship. Statements of the accused has already been taken, lordship. Further custodial detention, lordship, my humble submission may not be, lordship, required.
Not only petty but also 1,191 quintal of rice.
Yes, rice and paddy, lordship. Rice because it was seized from the rice mill. It was inside the campus of rice mill. So 1,000 quintal of rice was there, lordship. And this rice was seized by the inspector. Now this rice has already been handed over to the owner of the mill. Immediately it was seized, lordship. And this is the order of the London City of lordship. It has already been handed over to the owner of the mill. This person, lordship, is a staff of the mill, and rice paddy has already been handed over to the owner, and he's behind the bars since last 30 days, lordship. This is my humble submission. If his statement perhaps will be recorded, lordship. And considering the allegation level in the affair has been filed by the inspector of the supply. The allegation level. The lordship will find the zimma of the rice was given to this petitioner, lordship. And after giving zimma, lordship, he has been arrested.
Okay, let us take up.
Lordship will peruse the order of the zimma, the second page, lordship, the left hand side, lordship. The first page, left hand side, lordship. This is the original order, lordship.
Mr. Gogoi, when you will be able to produce the case?
This is from Morigaon, my lord. Any day next week, my lord.
Short, I mean,
Yes,
short,
yes,
lordship.
Can we try on Friday?
Friday it will be too short, my lord. Let it do 12 or 11, my lord.
Okay, I'm praying for lordship already 31st years.
Heard, Mr. Your good name?
S. Chakraborty, lordship.
S. Chakraborty, learned counsel for the accused, and also heard Mr. B.B. Gogoi, learned additional PP for the state response. Mr. Gogoi submits that he has not received the case diary and press for granting him some more time to produce the case diary before this court. Prayer of Mr. Gogoi is accordingly allowed. The case diary shall be produced before this court on next Monday.
Yes.
Item number 26.
May I take the back the zimma?
Yes, you can. Sorry.
His came report was called for.
Your lordship, earlier that diary, once we received, we sent back. Today not received, my lord.
Heard, Mr.
Brother.
Mr. P.K. Das.
P.K. Das, learned counsel for the applicant, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. Mr. Gogoi submits that he has received the case area on earlier occasion, but returned the same for updating. and therefore he has not received the case area and price for granting him some more time. Here is allowed. List the matter of when? 10th.
Item 28.
Offline. Second time bail application was it was called.
28. It's statute submitted here, madam.
Under section?
Section
326 and 307 lordship. 326 of 307.
Can you go and approach the trial court?
Lordship.
What is the number?
Yes. CS number 54/23, dated 30/9/23. 54/23.
The sections are available with him?
No, section not mentioned.
Heard Mr.
M. Alongir.
M. Alongir, learned counsel for the applicant, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. This application under section 438 CRTC is prepared by applicant Abdul Barik alias Barik Ali, who has been apprehending arrest in connection with Masir Sor PS case number 35 of 2023 under section 143, 341, 326, 307 IPC. Is to be noted here that above noted case has been registered on the basis of one FIR lodged by one Nurul Hussain. Annexer 1 is the FIR?
Lordship. Annexer 1 is the
Lodged by Nurul Hussain on 30/5/2023. The essence of allegation made in the FIR dated so and so is that on 27/5/2023 at about 9:30 p.m. accused Barik Ali, Abdul Jalil, Abdul Batin, Abdul Haq, and Swaib Ali Subahan Ali wrongfully restrained his maternal uncle, namely Asruddin, while he was proceeding along with his family members to the house of one Salam Ali, being armed with sharp object. And injured him seriously. Mr. Gogoi, learned counsel for the applicant, learned additional PP submits that he has not received the case diary, though the same was called for by order dated 17/10/2023. And 22/9/2023. But as per his instruction, the IO has already completed investigation and submitted charge sheet before the learned court below. In view of above, it is provided that the applicant shall approach the learned court below by filing an application for granting regular bail, and in the event of filing such an application, the learned court below shall consider the same in accordance with law. In terms of above, this may be disposed of. Within a period of
2 weeks, 24/1/24.
24/1.
Lordship, my heartfelt apologies, Lordship.
Yes.
Item 43, apart from the affidavit which you have filed today, Lordship, we had filed another one on December 27. So Lordship, that has not got back. If your Lordship allows, it may be brought on record. It is in the section, Lordship. For reasons unknown, it has not got.
Item number?
43.
CB was called for in this case.
Okay. Yes.
Item 29.
Your Lordship, here updated case diary was called for.
Yes, said that diary not received, my lord. We send back it earlier.
From who is PS? Who is PS?
My lord is Wakana PS case 89. My lord.
You have to look us up to the diary.
Hello, it's a second bail application in which my lord has called for the case diary with regard to up-to-date case diary.
So Gogoi when?
From Dhokwa Khana, my lord, 10 my lord.
No, the petition is pending for about 3 months.
Yes. Updated diary was called for.
Heard Ms. S.J. Bora, learned counsel for the applicant, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. Mr. Gogoi submits that the updated case diary has not been received and price for granting him some more time. Here is allowed. List the matter of when?
10.
10.
Item number 30.
Here diary not received.
As per my instruction, my lord, perhaps my lord, charge sheet has been submitted. If my learned, if you pen, my lord, take instruction, fix it here to my lord.
So charge sheet submitted.
As per my instruction, my lord, it will be confirmed by my lord colleague, my lord,
Yes,
at 2,
my
my lord,
At 2.
at 2 PM, my lord.
Okay.
31.
None appears for the applicant on call. List the matter after 1 week. On that day, learned additional PPSL for the case area before this court. Gogoi, is the case area available?
Diary available. Diary available.
Available.
Yes.
A letter of Mr. Gogoi submits that the case area is available and the case area will be retained till next date.
32.
32 search it submitted.
That's it under section.
It's of 376.
Along with
Here, my lord, instruction only that search it submitted. And number and date is there, my lord.
so you obtain instruction under which provision of law search sheet was submitted?
Maybe, yes.
At 2 PM then?
Yes, yes.
34. May please, your lordship. Lordship, this is a motion matter that's inadvertently come in hearing. On the last date, my lord, there is some confusion in the last order, my lord.
Under section.
My lord, it says that the Lord APP has submitted that case diary has not been received, but my lord, case diary was never called for in this case, my lord.
But we have instruction 34, na?
34.
Yeah, the statute.
So it's a charge sheeted case, my lord. We have
Already charge sheeted.
I mean,
Oh, yes.
this is a charge sheeted case, my lord, under section 376.
Yeah, because, yeah.
Okay, heard Mr. S. Nawaz, learned counsel for the applicant, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. This application under section 438 services prepared by applicant Monty Roy, alias Monty Roy, who has been apprehending arrest in connection with Gokaigao PS case number
But PRC case number. Page 1.
69 of 2020 under section 342, 448, 420, 376, 366 IPC corresponding to PRC case number 116 of 2023 under section 366, 376 IPC for grant of PRS bail. The learned counsel for the applicant submits that after completion of investigation, the IU has already laid charge sheet before the court of where it is pending now?
My lord, SDJM Gosaigao.
Pending before the court of learned SDJM Gokaigao. SDJM Gokaigao. But in view of the submission of learned counsel of both the parties, it is provided that registry shall call for the scanned copy of the record along with the case diary from the court of learned SDJM and Gokaigao, fixing the matter on 19.
Deeply.
Item 35.
CD was confirmed.
CD receipt case is registered, it was registered under section 320, section 307. Injury report is not there in the diary.
Well, what happened actually on the Lakshmi Puja day, Gokaigao there is a big mela. So all the friends, they went to enjoy the mela, and except this accused, my lord, others have taken heavily grant, my lord, and they are dashed to the there's a railing on the I river, my lord, and they were taken to the hospital immediately, and they were released, my lord, immediately next day. The FIR was lost by my own relation, my lord.
Besides summary, that report is here, my lord. Here it is shows that my lord, some injury in
Simple injuries there, my lord.
simple, that is not
Yes.
opinion. There
There is no
discharge.
They are discharged from the hospital.
Left finger.
My lord, I pray that I may be either in interim protection and let the medical report has come, whatever is there come.
Discharge. That is. I think
So the statement of the victim is there.
that is there, madam. That is there, madam.
To my information was that they sustained some injuries on the fingers, madam. I do not know, madam, kindly perusing, madam. An occurrence took place on 7th November. FIR lodged on 14th November.
Fracture is there.
Yes, fracture is there, finger.
Finger, madam. Because they are dashed to the railing of the river. Failed to control them because
By the petitioner.
Section kita itu আছে আমার।
So, as for a statement of the victim, there is amputation of 2 fingers. So let the medical report come. Mr. B.B. Gogoi, learned additional 50 submits that though he has received the case diary, yet the injury report of the victim is not available in the case diary and prays for granting him some more time to produce the injury report of the victim. Here is accordingly allowed. Place the matter on Monday.
But may I pray that until then I may be given protection. Whether that amputation is caused due to my assault, the allegation is assault, but they are dashed to they fell down because of their own fault.
Yes, a statement of the victim is there.
I have not assaulted, madam.
Statement of the victim is there.
Let it be 9, my lord, not 8.
9.
9.
Okay, 9.
Item 37.
Till then, protection ballot.
Yes.
City was called for lordship. FIR is
City receipt.
8 is the FIR lordship.
Yes, Gogoi injury report is there.
Yes, simple injury, my lord, that is there, my lord.
Caused by?
Upper limb, my lord, weapon here. Blunt.
Blunt.
It-
So 326 will not come then.
Yes, not come.
The other offenses are bailable.
Yes.
Or Mr.
M. Mondol.
M.
Mondol.
Mandal, learned counsel for the applicant, and also heard Mr. B.P. Godo, learned additional PP for the state respondent. Apprehending arrest in connection with Gauripur PS case number 374 of 2023. Under section 323, 325, 326, 34 IPC. This application under section 438 CRPC is preferred by 5 applicants, namely Asab Ali alias Sheikh, Ainuddin Sheikh, Sukur Ali alias Sukur Ali Sheikh, Azufa Khatun Bibi alias Azufa Bibi, Zubeda Khatun alias Bibi, for grant of periods rate. Is to be noted here that above noted case has been registered on the basis of one FIR lost by one. Where is the FIR?
Page 8, Lordship.
On the basis of one FIR lost by one Sundari Bibi on when it was filed.
Date is not there, Lordship.
On 30th/9/2023. Hmm? No, 1/10/2023. The essence of allegation made in the FIR dated so and so is that on 29/9/2023 at about 5 p.m. the husband of the informant, namely Rafiq Ali, who has been working as a contractor in Sona Sona Brickfield, Brick Clean, situated at Mazirigaon, Guwahati. Went to the house of Asab Ali Sheikh, who took a sum of rupees 85,000 for working in the brick clean. And while they asked the accused for returning the amount, then altercation took place between them, and accused Asab Ali Sheikh, along with other co-accused, assaulted her husband and injured her and her husband seriously. Her husband and her and also injured them seriously. The learned counsel for the applicant submits that so what is your submission?
Altercation took place, Lordship, but
Pardon?
Some altercation took place between them, but
Submits that except altercation, nothing has taken place between the applicant and the informant and her husband as alleged in the FIR, and that they are local person and ready to cooperate with the investigating agency, and therefore it is contented to allow the petition. On the other hand, Mr. B.B. Gogoi, learned additional PP, has produced the case diary before this court and submits that as per information, no, as per injury report of the victim, the injury sustained by him is simple in nature, caused by blunt object. Whether having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record. And it appears that the case was registered under section 323, 325, 326, 34 IPC. As indicated in the injury report of the victim, Rafiq Ali Mandal, the injury sustained by him is simple in nature, caused by a blunt object. And as such, no ingredients of the offense under section 326 IPC appears to be made out. Rest of the offenses are available. And in view of above, this court is inclined to dispose of this application by directing the applicants to appear before the learned court below and to apply for regular bail.
AB, my lord. He arrested.
Yes. And in the, pardon? So the other offenses are bailable, so we cannot grant you anticipatory bail. You go and appear before the court below and apply for regular bail. And to apply for regular bail. And in the event of filing such an application, the learned court below shall consider the same in accordance with law. In terms of this AB instance disposal, case diary be returned.
Okay. 38. Made pleasure lordship.
Yes.
My lord, the ad interim bail was granted and the CD was called for, my lord. Actually, my lord, the petitioner before lordship, he was working as a senior sub-registrar, my lord, at Guwahati. Now, the allegation against the petitioner is he issued a certified copy, my lord. And the original deed based on which the certified copy was issued, that was executed in the year 2006. And the petitioner came to be posted in Guwahati only in 2018. That was the consideration which was taken note of by this honorable court, my lord. And unless...
No, when he was posted in Guwahati?
2018. Now I have been posted out of Guwahati recently to Hosai. And the original deed based on which, my lord, this certified copy was issued by the petitioner, that too, my lord, after the process. Also, note there are several stages. Initially, there will be a report. Based on the report, my lord, of the Latmangal and all, then he normally issues the certificate copy. Somebody will write it, then it will be compared by somebody. Then only, my lord, he in the capacity of a sub-registrar or senior sub-registrar, he puts his signature, my lord. And my lord, there is nothing to, no, it was not, had it been a case where, my lord, the prosecution would have alleged that I had knowledge that the deed is, my lord, original deed is, my lord, fabricated or forged, then situation would have been different, my lord. So that is not the allegation in the FIR. Now the FIR is at page 18, my lord. with reference to the subject cited above, I'd like to bring to your kind attention that I have a plot of land at Betkusi under Dispur Circle, Beltola Moza behind Ayurusundra Hospital, which I purchased from Mrs. Lily Begum and Sons by no objection certificate from Deputy Commissioner Metro for transfer of the said land being so and so, and no objection certificate from Guwahati Metropolitan Development Authority by memo dated so and so, measuring 1 kata 10 lecha, etc., etc. After purchase of the land from the landowner, I have applied for a separate patta and Namjari on 3/11 in 11. Accordingly, an order was passed from the Dispur Revenue Circle for Namjari on 16/11/2021, and the said land transferred in my name. Periodic Kheras Patka so and so so and so. After completion of all official formality, I have developed my land by earth filling, brick boundary wall and iron gate, etc. I have grown different types of fruits, etc., etc., etc. And I have taken loan on the above land for business purpose. They have destroyed all the above trees by my own built house also. I am in a construction business and I have kept 10 MT of TMT steel, so and so, etc., etc. Next para. On last 11th of June 2023, suddenly Mintu Rabha, Mainul Haq, and Anil Musahari of Betkusi entered in my land along with approximately 50 doubtful persons by force in the midnight with preparing a false sale deed. When I came to know about the activity, immediately I proceeded to the land, but the above person threatened me not to come around the land, otherwise you will be harmed. Since 12 June 2023, I am moving here and there for justice, but till today no action has been taken from the concerned authority. Suddenly, I got information that one of the above miscreant, Mainul Haq, is arrested by crime branch department for doing use fake sale deed and other documents crime and is in police custody now. It is proved that they have prepared fake document and illegally occupied my land since 12th of June 23 to date. At present, on behalf of the above few people is staying in my plot of land. In other words, he wants to say, my lord, that he has been dispossessed and somebody else has taken over possession of the land on the strength of a fake deed. That is the allegation. Now, my only act which I think as a petitioner, as I know, my lord, since I am apprehending arrest, my apprehension was that I issued the certified copy of the original. Nothing beyond that. And original deed is of 2006. 2006. When one Mr. Gautam Sharma was the sub-registrar of Kamrup Metro. And I joined in 2016. 18, my lord, October 2018. In paragraph 4, we have clearly stated the whole thing, my lord. And in fact, my lord, in connection with this case, I appeared before Gorsuk police station on 14/12/23 and I gave my statement also. I was called, my statement was taken. In fact, my lord, by issuing a 160 CRPC notice, I was called. That notice is at, my lord, page number 20.
So after granting this interim protection,
yes,
or prior to that?
Prior to that, and even after granting of bail also, because there was an order that every alternate day I have to visit the police station, so I was doing, my lord. And on 30th in the morning, I again, my lord, appeared before the IO, and my request statement was recorded.
So after granting interim protection, when did you appear before the IO?
30, my lord.
30?
12.
Boroy, is there any entry to that effect in the case diary?
No, 30/12, after that 30/12, there is no entry, Lord, sir. After 29/12, Lord, sir.
It did not appear.
There is no entry, Lord, sir.
So when the case diary was forwarded from the IO concerned?
My lord, on 2/1, Lord, sir.
2/1.
2/1. Yesterday.
So,
Maybe because of the intervening holidays, my lord, Saturday, Sunday, New Year's.
no, is it sure that you have appeared?
Yes, yes, of course, no, yes. We have presented ourselves, my lord. And in fact, my lord, bail bond was accepted also.
Yeah, heard Mr. Ken Solure, Learned Senior Counsel assisted by Mr. Learned Counsel for the applicant, and also heard Mr. RJ Purva, Learned Additional PP for the state respondent.
Disposing of this matter.
Yes,
No matter, I have some objection also.
Yes.
Regarding this. But there is a note of the investigating officer also. That is, my lord, in a nutshell, what we have mentioned this, what we kindly pay. So there is a big conspiracy
no,
going on, my lord.
Borua, you say,
My lord,
if the original deed was executed in the year 2006,
my lord,
and the sub-register concerned has issued certified copy
my lord,
on the basis of said deed,
my lord.
what wrong is
That
with
is
it?
the conspiracy going on, lordship.
Pardon?
That is the conspiracy going on in the DC office, lordship. My lord, what they does, lordship, there are few people, lordship, few persons, including the advocate, then there are some official of the registration branch, lordship. They issued, lordship, this fake, my lord, registration, fake sending, lordship. That is why I flag mark the original sending also and the fake sending also, lordship. And he has certified the, my lord, sending, lordship, without verifying the record, lordship. Lordship has seen his statement, lordship. That is the statement prior to his arrest, lordship, probably. Or prior to his pre-arrest bail. Without verifying, lordship, he has issued this, my lord, certified copy, lordship. But a pink flag mark, lordship, may kindly present and the yellow flag mark, lordship. Case is not that, lordship, he has issued the certified copy, lordship. The entire conspiracy is based on the certified copy, lordship. The certified copy is fake.
The certified copy is usually issued on the basis of original deed.
Original deed, but that has to be verified by the official concerned, lordship. Without verifying it, if I apply certified copy of this honorable court, lordship, there are some division, lordship, they will verify it and they will furnish me the copy, lordship. Without verifying, lordship, if they give me a fake order, lordship, who will be responsible?
Mr. Borua, you saw this court. Where the materials to show that without verifying the record, he has issued the
My
certificate
lord,
copy.
lordship, may kindly peruse the yellow flag mark, lordship.
And even we
And the pink flag mark, the last portion, lordship.
even if we accept your submission that the government officer without verifying the record has issued a certificate copy,
My lord.
what offense it will?
My lord, he has committed, lordship, forgery, lordship, because this
Forgery.
entire certificate copy is, my lord, fake, lordship. He is a part of the conspiracy, lordship. And lordship may peruse the FIR, what he has mentioned in the FIR. Lordship may kindly peruse the FIR at page number, lordship.
No, in the FIR allegation is against some other persons.
Yes, this monologue, he is the main person, lordship. He along with the other person, including Ranjit Chaudhary, then one, my lord, 1000. They are the main conspirators, lordship. They issued this fake certificate. Okay, investigation is going on at this stage, lordship.
No. What fake certificate they have issued?
Well, there is a fake sale certificate, sent it, lordship. Certified copy of the sale deed, which is fake. It is also his duty to verify, lordship. He cannot, my lord, issue a certified copy without verifying the record.
If he issued a certificate copy without verifying the records, it will be a dereliction of duty.
Lordship may kindly peruse the, my lord, his statement, lordship. I have flag it
Which
pink color.
statement?
My lord, the accused person statement, lordship. My lord, in the pink color flag mark in the last paragraph, lordship, what he has stated.
No, this is the note recorded by the IO. But whether any witnesses have stated that he has conspired with other accused persons in
My lord.
forging the
Go to the
documents?
extent of the Nitul Das, lordship, Nitul Das, that I have flag marked in yellow color, lordship.
No, even then, he has already been granted PRS bail. He had appeared before the IO.
And it's documentary evidence already.
He has been
Question is, lordship,
cooperating with the investigating
what I have
agency.
submitted, lordship, that materials have been collected by the IO, and it is the objection of the investigating officer that his PRS
That's all right.
application should not be, my lord, extended, my lord. It should be rejected, lordship. Because it is the investigating officer who needs his interrogation, lordship. Who needs to speak to the lordship.
Is the person is behind the bar in connection
Now
with
he has
some
been
other
arrested,
matters?
lordship.
On 31st in the evening, my lord, he has been, tomorrow again, I am moving that petition. Now he has been arrested. That too in a different case arising out of the same transaction. Lordship knows that Uday Chand's case, Uday Chand versus Sheikh Mohammed Abdullah, where Honorable Supreme Court has said, my lord, they are supposed to inform the court on the day when they produce the case diary that this is the not the only case which is pending against him. There are other cases also. So that, my lord, tomorrow they cannot say once he is released on one case, then he will be arrested again. Then they must take leave from the honorable court. I am going to take that plea in the other case tomorrow, my lord. It's coming up tomorrow, na? Tomorrow. My lord, my humble submission is, my lord, recently I am seeing a trend, my lord, where certain personal opinions are being, submitted before the honorable court, which is being, conveyed by the IO or the, my lord, prosecution, and those are being told to the honorable court. At the end of the day, the CD must reveal that I have the knowledge that the original deed based on which I issued the certified copy is a fake one. But that allegation is not there, my lord. And neither in the FIR nor anywhere else. My lord, I'll give one example. Supposing I apply for a certified copy of an order issued by this honorable court. What this section will do, my lord, somebody will go through the original order, somebody will write it, somebody will compare it. Then he will sign it, then the issuing authority will issue it. Now, what fault that issuing authority has committed? End of the day, criminality is, if it is to be attached, then it must, that mens rea must be established, my lord. Mere subjective opinion of the IO that it is a case of conspiracy is not enough. As the lordship rightly pointed out, which is that statement which implicates the petitioner. There's none. The other day, my lord, when this case was moved, a submission was made that I am the kingpin of this case. But nothing was revealed from the case diary in another case. I've been enlarged on PRS bail in another case by this honorable court on the last working day, my lord. At the end of the day, these are all based on documentary evidence. How my custodial interrogation is going to help their cause, my lord? All the documents you are there.
The question is that, lordship, when a certificate copy we obtain, lordship, the person who issued the certificate copy, he compared the certificate copy along with the original one, lordship.
No, the sub-register usually not verify the
No,
record.
but he has
The stubs are there.
Well, he has to, lordship, because without verifying, lordship, he cannot issue
No,
certificate copy.
no.
Now the certificate
If
copy
he has to check each and every word of the document, it would not be possible to issue certified copy.
In fact, my lord, in paragraph 4, I have categorically stated that this original was issued at the time when one Gautam Sharma was the sub-registrar. Has he been questioned? Has he been arrested? He has not been done because there is a reason. This Gautam Sharma, my lord. I have made a categorical affirmation. Paragraph 4, please come to page 5, my lord.
Okay, 1 minute, Mr. Sharma.
My
So on what basis the ION is not recorded that he is the kingpin? Where is that material?
Material Lordship may kindly produce the statement of the other witnesses, Lordship, including the co-accused, Lordship, because the co-accused are, they are the FIR name accused person, Lordship. They are FIR name, Lordship.
No, that is only in respect of issuing certificate copy.
That certificate copy he has issued without verifying that it's totally fake. The certificate copy which he has issued, Lordship, that is totally fake.
No, but he has issued, he has certified it, but who prepared the same?
What is in it?
That is the conspiracy, Lordship. That is the conspiracy going. That is the conspiracy going on, Lordship.
My lord, will kindly permit me to place one paragraph, paragraph 4, my lord. Page 5. That the petitioner begs to state that as already mentioned above, he joined the sub-register Kamrup Metro on October 2018, whereas deed in question, which has been alleged to be forged, was executed in the year 2006. At that time, one Gautam Sharma was the sub-register Kamrup Metro Guwahati. The petitioner further states that the petitioner appeared before the Gorsuk police station on 14/12/23 and his statement was recorded by the investigating officer of the instant case. At that time, the investigating officer asked the petitioner about certified copy of the sale deed. Petitioner further states that he categorically informed that any certified copy of the sale deed was issued after verifying the sale deed by his subordinate staff, and there is 3 specific columns: read by, written by, compared by, and after that the certificate copy of the sale deed has been issued, which was done in the instant case. Petitioner further states that it is not within his knowledge that the alleged deed in question is not genuine as alleged. In other words, my lord, the original deed from which certified copy is alleged, that is forged. That is the case. Now, how am I, my lord, privy to that? What is the, I mean, the way I can verify that, my lord? There are, in the process, there are 3 persons are involved. Thereafter only I did it, my lord. As is being done in issuing certified copy in any order, my lord. It's a different matter that the original could be a force. Therefore, unless you, establish with materials that I have knowledge that the original is fake or false, then it's a different issue, my lord. Where are the materials to that effect? Is that he must reveal those materials, my lord. Then only I can be roped in this case.
The investigation is in very initial stage, Lordship, my lord. And this stage, Lordship, I am praying that this interim period bill should not be, my lord. Absolute.
Okay. Heard Mr. Sotore, learned senior counsel assisted by Mr. Learned counsel for the applicant, and also heard Mr. RJ Boro, learned additional BP for the state respondent. Apprehending, arresting connection with Gorsuk PS case number 324 of 2023 under section 120B, 467, 468, 447, 427, 379 IPC. This application under section 438 services prepared by applicant Ramjit Chaudhary for grant of real estate is to be noted here that above noted case is being registered on the basis of one Dhanraj Parit on 29/11/2023. The essence of allegation made in the FIR dated so and so is that on 11 June 2023, one Mintu Rabha, Moinul Haq within bracket advocate, and Mr. Onil Musahari of Betkusi entered into his land along with 50 doubtful persons in the midnight, preparing fake sale deed. And when he knowing about the same, when he proceeded to the to his land, then the aforesaid persons threatened him not to come to his land. Mr. Ken Sodore, learned senior counsel for the applicant, submits that this court was placed to grant interim protection to the applicant by order dated 22/12/2023. In person to the said order, the applicant had appeared before the IO on 30/12/2023, and he has been cooperating with the investigating agency. Mr. Sodore further submits that the applicant had received one notice under section 160 CRPC from the IO concerned, and pursuant to the said notice, he had appeared before the IO on 14/10/2023, and he has been cooperating with the investigating agency, and that the allegation against the applicant is that he has issued a certified copy of a deed which was executed in the year 2006, and at that point of time when Gautam Sharma was the sub-register of the office of the sub-register Kamrup, and the present applicant joined as sub-register in the month of October 2018, and that even if the allegation made in the FIR dated so and so is taken into account, no offense under section 120B, 467, 468, 447, 427, 379 IPC appears to be made out against the present applicant, and therefore Mr. Sodore contended to make the interim order dated 22/12/2023 absolute in the same terms and conditions. On the other hand, Mr. R.J. Borwa, learned additional PP, has produced the case before this court and submits that the IO has collected sufficient incriminating materials against the applicant, and therefore Mr. Borwa has vehemently opposed the petition and contended to dismiss the same. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record, and also perused the case daily with the assistance of Mr. Borwa, learned additional PP. It is not in dispute that person to order dated 22/12/2023, the applicant had appeared before the IO, and prior to that day also on 14/10/2023, the applicant had appeared before the IO pursuant to a notice received by him issued under section 160 CRPC. Thus, it appears that he has been cooperating with the investigating agency. It also appears from the record that the IO has achieved substantial progress in the investigation of the case. And in view of the materials collected so far in the case area, and also in view of the submission so advanced by learned advocates of both the parties, custodial interrogation of the applicant seems to be not warranted in the interest of investigation of the case, and therefore this court is inclined to make the interim order dated 22/12/23 absolute in the same terms and conditions. Terms of above this abuse and disposal of CDB.
Respectfully begs to state that on 27/10/2023 at about 8:15 p.m. while I was cooking rice alone in my home, the below stated accused person with ill motive entered into my house and pressed my mouth with pillow and tried to commit rape. At that time, my daughter, namely Rashida Khatun, came to my house and seen that the accused person pressed my, sorry, your lordship. At that time, my daughter, namely Rashida Khatun, came to my house and seen that the accused was pressed my mouth with pillow. Then she started hue and cry. Then my nephew, namely Abdul Rashid, by running, entered into my house, though nabbed the accused person, but the accused person by hitting fell down him and fled away from there by taking advantage of darkness, lordship. This is the FIR, lordship. Lordship, actual fact of this case is that, lordship, house of the victim woman situated in the land of the accused petitioner, lordship. And in pursuance of that, there is a land dispute between the parties going on since long back, lordship. And they are taking given temporary shelter to them by constructing temporary house in their own land. And thereby there is a land dispute going on between the parties, lordship. CD will reveal everything, lordship. CD may be called for, and in the meantime, lordship, meantime protection may be given, lordship.
He has been named in the FIR, lordship. At this stage, I'll try to call for a case there, lordship.
Yes, lordship, CD is required in this case, lordship. I'm paying for, lordship, meantime protection, lordship.
Heard, Mr. Your good name?
AK Azhar, lordship.
AK Azhar, learned counsel for the applicant, and also heard Mr. Arjay Barua, learned additional PP for the state respondent. Apprehending arrest in connection with Gauripur Peace case number 432 of 2023 under section 448, 376, 511 IPC. This application under section 438 services prepared by applicant Gul Hussain for grant of previous bail. The above noted case has been registered on the basis of an FIR lodged by one Srimati X name withheld on 28/10/2023. The essence of allegation made in the FIR dated so and so is that on 29/10/2023 at about 8:15 p.m. while she was preparing her meal, then the accused, namely Gul Hussain, entered into her house and pressed her mouth and attempted to commit rape upon her. Having heard the submission of learned advocates of both sides, and also considering the nature of allegation made in the FIR dated so and so, perusal of the case diary is found to be necessary, and accordingly it is provided that the learned additional PP shall produce the case diary before this court on
22nd.
22nd. Sorted?
Can it be on 15?
Okay, 15.
15 is only.
Having regard to the nature of accusation and also the submission of learned advocates of both sides, this court is not inclined to extend any interim protection to the applicant at this stage.
9.
Coming item 10.
Thank you.
Item number 10, lordship, case diary, my lord, it was lying in our office, lordship. So since it has come in the motion stage, lordship, my lord mentioned it, my lord, that case diary was available in the office. An injury report I have paid, lordship, that is simple, lordship, caused by blunt, lordship.
Case diary is available.
It was my lord lying in our office, lordship. They did not.
Okay, tomorrow we will produce it.
Yes, so tomorrow. Now today we have brought the case diary, lordship. The lordship is directed to my lord, to call the matter again at 2 p.m. lordship.
Okay.
We have brought the case diary.
The case diary is available.
Yes, yes, it is.
Acha. So is there any material against the president?
Regarding assault is there, but the injury sustained is simple in nature and caused by
blunt weapon was.
On which part of body he got the injury?
My lord, in face and my lord in the my lord hand. Face, forehead, and my lord hand and neck.
So head is the vital part of the body. Maybe the injury is simple. Can it be said that offense under section 307 is not made out?
To that extent, also injury is there or not, no, that is also part of it.
Pardon?
No, to that extent, Lordship, the injury, how much injury is there in head, Lordship, it mentioned, Lordship.
No, is it necessary that to attract section 307, the
Yeah,
each and every injury has to be grievous in nature? Is it the requirement of section 307?
No, fact of the case is that there was push and Lordship, there was a bowl was there, Lordship. He assaulted an elderly person. Thereafter, people of the marriage party, Lordship, came out and arrested him, Lordship.
Yes, Mr. Borwa,
My lord.
what is the statement of the victim?
He himself is the informant. Informant is the victim, Lordship. He himself.
My lord, there are my lord, he has implicated 4 accused persons in his statement, lordship. Bhola Shah, Nobin Ray, Lokesh Roy, মোক লাঠি ৰড আৰু ইটাৰে মাৰপিট কৰি গুৰুতৰ জখম কৰে।
It was not to that extent only because Lordship, he was released by the same time, Lordship.
Can I see the case diary? Yeah, heard Mr. Munir, learned counsel for the applicant, and also heard Mr. Harja Barua, learned medicinal applicant for the state respondent. Apprehending arrest in connection with Bhangagar case number 310, 2023 under section 341, 325, 307, 392 IPC. This application under section 438 service is deferred by applicant Nobin Rai for grant of previous bail. The above case has been registered on the basis of one FIR lodged by one Minal Bara on 27/11/2023. The essence of allegation made in the FIR dated so is that on 27/11/2023 at about 2 a.m. while he was returning from a marriage party at Hatiyog, four persons, namely one Bhola Saha, Nobin Rai, Lokesh Rai, and others, assaulted him at Torun Nagar. While he asked them to remove their bike from the way. The learned counsel for the applicant, Mr. Monet, submits that while order dated 18/12/2023 in BA number 4502/2023, this court was pleased to grant bail to one of the co-accused, namely Bhola Shah, on the ground that the injuries sustained by the informant was simple in nature. And that the accused or the applicant is ready to cooperate with the investigating agency, and therefore it is contended to allow the petition. On the other hand, Mr. Arjay Borwa, learned additional PP, has produced the case area before this court and submits that so all these injury reports belongs to the accused persons also.
No, only the first one is belongs to the mother informant. First one.
First one is of informant.
Mother, Binal Bora.
And his statement is page number?
Yes, it is about, I have flagged it also.
Is red mark?
Yes, red color.
No, it is of accused Burlasa.
It is the latter part of the case that is.
Other hand, Mr. Arjay Borwa, learned additional PP, has produced the case area before this court and submits that though the injury sustained by the victim, public informant, is simple in nature caused by blunt weapon, yet the IO has collected sufficient and incriminating materials in support of the allegation made in the FIR, and therefore Mr. Borwa has contended to dismiss the petition. Having heard the submission of learned advocates of both sides, I have carefully gone through the petition and the documents placed on record and also perused the case area with the assistance of Mr. Borwa, learned additional PP. It appears that the IO has got the informant, public victim, examined by doctor and collect the report, which is available in the case area, and the same indicates that the informant got simple injuries. Caused by a blunt object. And the injuries as described in the injury report are swelling over forehead, and multiple abrasion over face and multiple abrasion over neck. Further, it appears that one of the co-accused has already been enlarged on bail by this court by order dated 18/12/2023 in BA number 4502 of 2023. Having considered above and also considering the submission of learned advocates of both sides, as well as the materials collected so far in the case diary, custodial interrogation of the applicant seems to be not warranted here in this case, and therefore this court is inclined to allow this petition. It is provided that in the event of arrest of the applicant in Bangor PS case number so-and-so under section so-and-so, he shall be released on pre-arrest bail on his executing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. First condition is shall not leave the jurisdiction of CJN Kamrup M without prior permission. In terms of above, this AB is disposed of CD visitor.
Much obliged, Your Lordship, much obliged.
Pending item 30 for bail hearing.
Charges submitted.
Charge number?
Madam, charge number 352/2023, dated 6/11/2023.
Under section?
Under section, Madam, 143, 147, 326, and 307 also.
Okay, you go and appear before the trial court.
Till then, my lord, interim order may be, my lord.
He is on interim bail.
Yes, my lord. Order dated 8/11/23.
Okay. Heard, Mr.
TK Bhuiyan.
TK Bhuiyan, learned counsel for the applicant, and also heard Mr. Arjay Barua, learned additional PP for the state respondent. Apprehending arrest in connection with Dolgaon PS case number 350 of 2023 under section 143, 147, 326, 325, 307 IPC. This application under section 438 service is prepared by three applicants, namely Wajib Ali alias Wazed Ali, Fulesa Khatun alias Fulesa Begum, and Habez Ali for grant of pre-arrest bail. The above noted case has been registered on the basis of one FIR lost by one. FIR is a page number?
Page number, my lord, 9. Relevant is page 15. Is the Bhanegular, my lord.
On the basis of one FIR lost by one.
Khadija Begum.
Page number?
The Bhanegular is page 15, my lord. And type copy, your lordship will find at page 9.
The basis of one FIR lost by one Khadija Begum.
Dated 8/10
on 8/10/2023. The essence of allegation made in the FIR dated so and so is that on the night of 8/10/2023 at about 1:30 AM, one Hussein Ali, Saib Ali, Hasmot Ali, Wazed Ali, Saifuddin, Habez Ali, Ahmed Ali, Asmot Ali, and Fulesa Begum, and Sirazul Haq.
10%.
tried to construct a road on their on her land, and while she raised objection, she along with her family members raised objection, then the accused persons assaulted
Bahar Ali, Hafiza Begum, Hawa Begum, and Amina Khatun. মোৰ স্বামী বাহাৰ আলী আগবাঢ়ি যোৱাত স্বামীকো মাৰপিট কৰি জখম কৰে মোৰ ননদী হাফিজা বেগমক
assaulted her father-in-law Alfaz Ali, her husband Bahar Ali, and her sister-in-law Habiza Begum, and Hawa Begum, and her daughter Amina Begum, and injured them seriously. Mr. Punya, Learned Counsel for the applicant submits that by order dated 8/11/2023, this court was placed to extend interim protection to the applicants. And person to the said order, you have appeared before the IO? That person to the said order, all the applicants have appeared before the IO and they have been cooperating with the investigating agency, and therefore it is contented to make the interim order dated 8/11/2023 absolute in the same terms and condition. Whereas Mr. Arzabrega, learned additional PP submits that. After completion of investigation, the IO has submitted charge sheet against the applicants, being charge sheet number 352 of 2023, dated 6/11/2023, under section 143, 147, 326, 307 IPC. In view of the submission of learned advocates of both sides, and also in view of the fact that investigation of the case has already been completed and charge sheet has been submitted before the learned court below, this court is inclined to dispose of this application by directing the applicants to appear before the court below, learned court below, and to apply for regular bail. And in the event of filing such an application, the learned court below shall consider the same in accordance with law. Till then, the honor before
24/1.
24/1.
My lord.
Till then, interim order dated 8/11/2023 stands extended. In terms of this, AB is not disposal of CDB return. No,
If you have
CD not.
Is there
CD,
no-
CD.
Turning item 32.
Yes, Lordship, we have instruction that under section, your Lordship directed me to take instruction.
Yes.
Under what section statute submitted now?
54 of 2023.
Yes,
Under section
448, 354, 325, 307.
heard Mr. Learned Counsel for the applicant, and also heard Mr. K.B. Gogoi, learned additional PP for the state respondent. Apprehending arrest in connection with Dhokwakhana PS case number 126 of 2023 under section 448, 376, 511, 307, 325 IPC. This application under section 438 services prepared by applicant Devojit Gogoi for grant of previous bail. The above noted case has been registered on the basis of one FIR lodged by one. one Hira Somua on when it was filed?
22/10/23.
On 22/10/2023. The essence of allegation made in the affair dated so and so is that on 28/10/2023, one boy came to his aunt's house and attempted to commit rape and murder. And cause multiple injuries on her person with the key of his bike. So what is your submission?
My lord, actually, the son of the victim and the petitioner were good friend, my lord. And the son of the victim and petitioner went to fishing. And suddenly the son of the victim returned to his house without informing anything to the petitioner. And at evening when petitioner went to his house, his mother shouted that you kill my son. Because both of them went to fishing, my lord. No such incident took place, my lord.
The learned counsel for the applicant submits that the applicant and the son of the victim
Yes, my lord.
are friends and they went for fishing, and then the applicant, without informing the son of the informant, returned home, and then without informing the son of the victim, returned home, and then the victim alleged that the applicant had killed her son, and that no such incident, as alleged in the affair, had ever taken place, and therefore it is contended to allow this petition. On the other hand, Mr. B.B. Gogoi, learned additional PP, submits that though case that he was called for, the same has not been received. And as per his instruction, the IU has completed investigation and submitted charge sheet, being charge sheet number 54 of 2023, dated 30/9/2023, under section 448, 354, 325, 307 IPC. Having heard the submission of learned advocates of both sides, I have gone through the petition and the documents placed on record. And considering the submission of learned advocates of both sides, this court is inclined to dispose of this petition by directing the applicant to appear before the learned SDGM Dokwakhana.
Yes, ma'am.
And to apply for regular bail, and in the event of filing such an application, the court below shall consider the same in accordance with law. Till then, within
22/1/24.
22. Till then, this court is inclined to extend interim protection to the applicant. And it is provided that in the event of arrest of the applicant in connection with case number so and so, he shall be released on pre-arrest bail on his executing a bond of rupees 50,000 with 1 security of like amount to the satisfaction of the arresting authority. The above privilege is, however, subject to the following three conditions. Number one, he shall appear before the IO on so and so. No, not IO, before the court below. And number two and three, that usual. In terms of above, this AB stands to dispose of, case there is not necessary.
Right, sir.
39 matters for orders.
Lordship, as per office note dated 15/12, my lord. Service upon respondent number 2 is awaited, my lord. And scan copy was called for, that has been received, my lord.
So what to do? You want to take fresh step?
Lordship.
Heard Ms. P. Bora, learned counsel for the petitioner, and also heard Mr. A.K. Boyso, learned additional PP for the state respondent. Office note dated 15/12/2023 indicates that service report upon respondent number 2 is still awaited. However, scan copy of the record of special case number 5 of 2021 has been received from the Court of Learned Special Judge Assam. The learned counsel for the petitioner submits that she will take fresh step upon respondent number 2. And accordingly, it is provided that step be taken upon respondent number 2 by registered post and also by usual process and also through the officer in charge jurisdictional PS within a week from today. List the matter after 3 weeks or 4 weeks?
After 3 weeks, my lord.
3 weeks.
Item 40.
Please, your lordship. Lordship, I have for condonation of delay only 306 days.
Only for?
306 days, lordship.
Lordship,
You are for respondent?
respondent number 1, Lordship.
So any objection in?
I have registered no objection in my affidavit, Lordship. Otherwise, I leave it
You
up
have
to
filed affidavit?
Yes, Lordship.
When?
This year only, Lordship.
This year means today is the first day.
22/6/23, lordship. I have received this.
It has not been taken. Has yet been received by the 6th. So have you inquired why it was not taken to the record?
Lordship, I have not inquired, Lordship.
Might be it is defective, therefore the registry has not put it up.
Lordship, had it been so, Lordship?
So you go and inquire, we will fix a short date.
Lordship.
Heard, Mr. Your good name?
Lordship.
Learned counsel for the petitioner, no, applicant, and also heard, Mr.
PP Medhi, Lordship.
PP Medhi, learned counsel for the respondent number 1, and Mr. Boisho for respondent number 2. Mr. Medhi, learned counsel for the respondent number 1, submits that he has filed affidavit. No, he has filed objection in this petition. But the said objection is not taken with the record. Accordingly, it is provided that registry shall take the objection with this application and list the matter on Monday.
8. Lordship, right. I can inquire by Monday.
8/1.
Lordship.
Obliged.
41.
Transfer matter, getting transfer of the maintenance case from Johar to DP. On 7 November Lordship also heard the matter, fix the matter for order. We also.
Yes, yes.
Yes.
So though notice was issued to the other side, the other side have not appeared. Okay. Heard, Mr. Your good name?
C. Chakraborty, ma'am.
C.
Chakraborty,
Learned counsel for the petitioner.
my lord.
And also heard Mr. A. Bashaw, learned additional PP. For the state respondent number 1, none appears for the respondent number 2, though notice was served upon her. This application under section 407 CPC is filed, is prepared by the petitioner, namely Sri Partho Ghosh, for transferring Miss case number 104 of 2022 pending before the Court of Learned Judicial Magistrate First Class Jorhat, Assam, to the Court of Learned Chief Judicial Magistrate Dibrugarh, Assam. The learned counsel for the petitioner submits that the respondent number 2 is the married wife of the petitioner, and presently she has been residing at Jorhat. And she has filed one miss case, being miss case number 104 of 2022, for granting her maintenance from the petitioner. The learned counsel for the petitioner further submits that the petitioner has instituted one divorce proceeding, which is pending before the Court of Learned District Judge Dibrugarh, being. What is the number of the case?
Title suit 106.
Being title suit number 3 of 2021.
106 of 22.
Acha, 3 is a restitution for conjugal right. Whether that petition was disposed of?
Firstly, we have filed a restitution that was disposed of expertly. After that, we filed a notice. In that, the hospital is contesting my lord.
Where you have mentioned?
24, my lord. Grounds.
File 1 divorce suit. No, file 1 title suit, being title suit written bracket divorce number 106 of 2022. And the same is pending at the stage of, at what stage the same is pending?
Any evidence stage.
In the stage of evidence. Any other cases pending against the petition, no, respondent?
In that divorce matter, she is filed one counter claim.
No, any domestic violence case?
Initially, it was filed, my lord.
That was disposed of. Settled. So what is the ground for which you have prayed for transferring the case?
Basically, we have filed a divorce matter at Dibrugarh, matter. And in that case, he was contesting. He also filed counter claim. She regularly appeared. My 2 children are with me. children are with me. And one daughter is about 10 years and boy is about 7 years. Presently, the daughter is suffering from some leg problem. So I have to take her to Chennai last October month.
She's suffering from?
Some leg problem. I have already on last date and submit some medical documents. And that's one record.
The learned counsel for the petitioner further submits that the petitioner has one daughter and one son, and they are residing with him, and the daughter is suffering from problem of neck and
swelling of neck,
swelling of neck, and the petitioner has to take her to the hospital for treatment. And and it is difficult for him to attend the court. No, attend the court at Zorat in connection with Miss case number 104 of 2022, and since another proceeding being title suit number so and so is pending in the court of Dibrugarh, in the court of district judge Dibrugarh, the learned counsel for the petitioner submits that this the miss case number so and so, which is pending before the court of judicial magistrate first class Zorat, may be transferred to the court of chief judicial magistrate Dibrugarh. Mr. Boyso, have you any objection? It is to be noted here that though notice upon the respondent number 2 was served, yet she has failed to turn up, and Mr. Boyso learned additional PP for the respondent number 1 submits that he has no objection in the event of allowing this petition. Having heard the submission of learned advocates of both sides, especially considering the fact that title suit number so and so is pending before the court of learned district judge Dibrugarh, in which the petitioner, no, which the respondent has already appeared and submitted WS. And also considering the fact that the daughter of the petitioner is suffering from ailments and there is none to look after them, this court is inclined to allow this petition. It is provided that Miss case number 104 of 2022 under section 125 CRPC, pending in the court of learned judicial magistrate first class Zorat, be transferred to the court of chief judicial magistrate Dibrugarh. In terms of this petition is disclosure.
42.
None appears for the petitioner on call. This is the matter after 1 week. In the event of subsequent non-appearance, appropriate order shall follow.
43 and 44.
May I please? Lordship 438, where the city was called for. I am in India.
The city receipt.
Sorry.
Why this IA?
My lord, I as an informant, my lord, has filed an IA, my lord, objecting to the bail. I am a rape victim, my lord, and rape had been committed upon me.
with the allegation.
No, if I file objection in the main petition also, why this IA?
No, my lord, IA in connection with the, my lord, anticipatory bail application which they have preferred.
Any relief was granted to them?
Yes, yes, interim protection has been provided, my lord, by taking records of the interim, my lord. Certain records are there, they have interfered with the investigation.
How they have interfered?
My lord.
How the applicant has interfered with the investigation?
My lord, the certain phone calls and threatenings are also being, my lord, advanced to the informant as well as her husband that if you do not withdraw the case. My lord, what has happened, both the, my lord, petitioner and the husband of the victim are the army personnel, my lord, working at the army camp at Narangi in the different posts. That's, my lord, due to the certain relationships, my lord, by taking advantage of the same. This my lord, crime has been committed. Even, my lord, I was conceived and I did approach before this honorable court, my lord, for termination of the fetus. And this honorable court in a writ petition, my lord, allowed the termination. My lord, may hear my respected senior friend first, my lord, then I will submit. If my lordship allows me, my lord, and on that.
Yes.
Lordship, this is a false case, totally false case, my lord. FIR, my lord, page 13, my lord. This is not first FIR, my lord, that is the second FIR. Earlier also they have filed one FIR, that is the page 19, my lord. That things already my learned friend surface in here affidavit. He has not stated about the first FIR, my lord. Lordship, first FIR, she has filed 13/6/2023, my lord, page 19 of my bail petition, my lord.
Page
19, my lord, 19.
Yes.
My lord, in this FIR, my lord, she has nowhere stated about the RAM, my lord. Date 8/4/2023. And then I'm going to read the FIR too. I, Soneka Praveen, wife of so and so, and I am 1.5 months pregnant, and I beg to stay before you in our police station and complain that 8/4/2023 said Munindra Kumar entered into our quarter and that incident was already made as a complaint before Army Department, and department inquiry is going on, but the decision is yet to come. Then on 6/6/2023 Thursday, my husband was on night duty in the unit, and that night only Munindra Kumar came into our quarter at around 11:45 PM and pressed the calling bell for twice, and when I opened the door, I saw Munindra Kumar was there, and I tried to close the door. Then he puts the door and come inside. When I tried to shout, then he hold my mouth with his hand, and within
case, and in this case, Lordships, the number is different. It ought to have been 1200. In place of it, it is 2384, Lordships. There's a slight error in the case number, Lordships. The other case number has been written in this as well. This ought to have been 1200 because the corresponding case is 1200. Since a common judgment was passed.
No, 1200 of 20 of which year?
2001, 2 Lordships.
2002.
Yes, Lordships.
And it was written as?
It was 2835. 2834 Lordships.
2834 of
2001 Lordships. They were all heard.
So instead of 2835 2001, it should have been
1200
1200 of 2002.
Lordships. There are the same error has been recorded in para 1, 2, 4, 16 and 19 Lordships.
1,
1, 2, para 4,
no, in the paragraph,
yes, Lordship, in the paragraph in the judgment,
1,
1, 2,
hmm,
4, 16 and 19, Lordships.
hmm.
Sixteen and 19. The order in the operative order is at at para 19, Lordship. Because of this, we had gone back to the lower court. Because of this mistake, they could not they could not pass in the appropriate order, Lordship.
So Gogoi, have you gone through it?
Private party is there.
Okay.
They are all parties who have filed the petition. They are also directors in the same case. All are directors of the same company, Lordships. They're joint petitions. The other two are correct, Lordship. Only in this that mistake has been done.
Heard Ms. S. Chakrabarty, learned counsel for the applicant, and also heard Mr. B.B. Gogoi, learned additional PP for the state respondent. This interlocutory application is filed by the applicant. Namely, 7 applicants are there in page number 2 and 3. 7 applicants, namely so and so, so and so. For correction of typographical error that occurred in the order dated 30/5/2022, passed by this court in criminal revision petition number 151 of 2020. In SEER case number 1200 of 2020, 2002. And no. Ms. Chakrabarty, learned counsel for the applicant, submits that while passing the judgment, passing the judgment in criminal revision petition number 151 of 2020, this court while allowing the petition, while allowing the said revision petition in paragraph number 1, in paragraph number 2, paragraph number 4,
Sixteen and 19.
And in 16 and in paragraph number 19 has wrongly mentioned the number of the SEER case as 2834/2001 instead of 1200 of 2002 of 2002. And therefore, Ms. Chakrabarty contended that the above typographical mistake may be corrected. Mr. B.B. Gogoi, learned additional PP, also submits that in the judgment dated 38/5/2022, in the aforementioned paragraph, the number of SEER case has been mentioned as 2834 of 2001 instead of 1200 of 2002. Having heard the submission of learned advocates of both sides, I have gone through the petition. gone through this application and the documents placed on record and the order date and the judgment dated 38/5/2022 passed by this court. It appears that the number of CRKs has been mentioned in the aforesaid judgment as 2834 of 2001 instead of 1200 of 2002. In the paragraph number 1, 2, 4, and 16 and 19. Accordingly, it is provided that the number of the CRKs in the aforesaid order, in the aforesaid judgment shall be read as 1200 of 2002 instead of 2834 of 2001 for all purpose. In terms of above, this IA stands at disposal.
Deeply obliged, lordships.
46.
Have this lordship as per last date order 6/11/2023, my lord. Learned PP was asked to produce the report from the police station, my lord, regarding the vehicle.
Gogo, you received the report?
Sorry, my lord, the report not received. A short date may be given, my lord, Nunmati.
My lord.
We will take next step.
Almost 1 year, my lord, my car is under the open sky, my lord. That is the only source of income of my family.
All right, let the APP produce the report. Heard Mr. P.S. Bhattacharya, learned counsel for the petitioner, and also heard Mr. B.V. Gogoi, learned additional PP for the state respondent. Mr. Gogoi submits that though by the order dated 6/11/2023, he was asked to produce the report as to the requirement of the vehicle number SES09C0488 for the purpose of investigation or not. Yet he has not received the report from the concerned PS and prays for granting him some time. Here is allowed. List the matter on when?
10.
10. Okay.
47.
My lordship, we have need some instruction from the petitioner. We pass about the for this matter for today.
Pardon?
For today, pass over the matter.
Acha. You have heard a
Respondent.
respondent. No, who filed this IA?
I can petitioner.
You are the petitioner.
Yes.
They have filed a vacation petition that is to be heard today. If it's 6 time, I have no objection, but interim may kindly continue.
Okay. Heard Mr. Your good name?
Yes, sir.
S. Hussain, learned counsel for the applicant, and also heard Mr. M. Mahmood, learned counsel for the respondent.
Petitioner.
No, in this IA, you are respondent.
Yes, opposite party.
Opposite party. The learned counsel for the applicant submits that he has been awaiting instruction from the petitioner.
Applicants.
From the petitioner and prays for listening the matter in the next week.
So day after tomorrow.
Okay.
Day after tomorrow.
Day after tomorrow. Yes.
I have no objection.
No objection. Okay. There is accordingly allowed.
Too early.
Shall list the matter on.
It's too early. At least 2 weeks should be there.
Monday.
Okay, after vacation then.
Monday.
Monday. Okay. Till then, interim order passed in criminal petition number 99935 shall continue.